To mention a matter for my lord upgradation, my lord. My lord is item number 868. My lord, the urgency is that, my lord, I am a senior citizen. My lord, I had gotten a tender. My lord, my tender has been terminated. My lord, I have completed 99% of the work, then my tender has been terminated. Now, my lord, they are raising the electricity bills of the said plot where the tender I was working at the project site, and they are pressurizing me to pay the electricity bills of that plot, my lord.
Your writ petition was dismissed.
My lord.
Please.
Lordship, I'm praying for leave to move this application in person. It's a PIL, your Lordship, regarding the implementation of RK Raghavan committee regarding the regarding the ragging, your Lordship. Ragging. Lordship, the urgency is, your Lordship. Lordship, fresh batch in the college for the first year, your Lordship, they have get the admission. And on the last week, an incident took place in the Jadavpur University. So for Lordship, I have annexed all the documents in there, your Lordship. It's a detailed report. A recommendation is there, your Lordship, but that has not yet been implemented, your Lordship.
The university has to implement it.
The UGC and through all the college, your Lordship, they have not implement all those points. It's a detailed report and the detailed recommendation, your Lordship, I have annexed there.
Leave granted.
Grateful,
Well,
Lordship.
may I permit to mention, well, early hearing of this PIL, which was filed on 11th of August, Friday. The urgency is this, my lord, with the fake domicile issued by the different districts. Several candidates have applied for the appointment in the defense, that is the VSF and the other organs. Now, my lord, the selection process almost been completed. 2 or 3 FIR has been registered, several complaint has been done. Well, this is a serious concern, my lord, where the fake domicile has been issued without doing anything. And this person, this candidate, who are going to be selected, they'll be deployed in the sector of defense. That is a national security. If they're Indian, then fine.
But then they will do some verification.
Well, that is the most surprising thing. The verification is nothing, only to verify the original with the document have been submitted at the time of application.
No, that is correct. Post after scrutiny of the application.
Nothing is there, my lord. I have given the entire recruitment. I have gone through the entire recruitment notice. That is the most surprising thing. That the document verification process is the most important. The document verification process is that.
And it's in the monthly list.
No, my lord, I have filed on the last Friday. That is the 11th of August.
Yes, then it will come automatically.
Well, at the early hearing, I'm praying for early hearing.
We'll do it. Fresh cases will be included.
Fresh cases that's supposed to be appeared on 21st of August. Within the 10 matters, my lord, I'm praying for within the 10 matters so that I can complete the service and everything. I'm grateful, my lord.
May I have losses kindly, my lord, one upgradation, my lord, grounds I have stated, my lord. I'm
You
not wasting your lordship's time, my lord. It is stated here.
May I be permitted to mention for inclusion of the
inclusion.
My lords, may I be permitted to mention for upgradation of the matter? It's 7:30 in my lord's monthly list. The issue is, my lords, I'm the owner of a land. I'm supposed to build an industrial park. Since this public interest litigation has been filed, I'm not getting the requisite certificate license required and it's being stalled.
May I be permitted to mention for the inclusion, my lord, this was earlier dismissed for default. We are filing the restoration application.
Application will be.
May I be permitted to mention a matter for upgradation, my lord? It's an item number 92 in the daily list, my lord.
92 is high enough.
No, my lord, this is that matter regarding encroachment of wetlands and illegal constructions thereon.
Please wait. Today we have listed these election matters. Some time will take.
Non-prosecution.
I was seeking your lordship's kind leave, that matter I had mentioned, last Friday. It has come up in the list as 97. That Unani Council matter, that registrar is functioning, illegally. May it be taken up at 2 p.m. I'll serve notice.
2 p.m. difficult. Today it will be difficult.
Today lot of what I am anticipating is, your lordship's court's order is being given a go by the person, he has taken charge as the registrar, and it is he, the Honorable Chief Justice, then, it is a categorical finding that he is instrumental in issuing the fake doctors. Fake doctors are functioning.
Let us see. You just wait for some time. Let us see how we progress today.
My lord, I am the petitioner of FMA number 872 of 2021. My lord, the matter is pending for more than 6 months only for order. Because on 4th January, the matter, after holding hearing in presence of all the parties, their lordships, Honorable ex-Chief Justice and Honorable Justice Rajarshi Bharadwaj, passed their order directing the OC Moisadol PS to appear personally before the court and to submit the inquiry report on 15th February. Accordingly, personal appearance of the OC has been dispensed with and the inquiry report also has been submitted.
Very good.
But no order was passed due to the siege work before the death, because of the death of a senior advocate. So from that time, the matter.
It is not in the list.
No, my lord.
Yes,
It is
yes.
listed, but
Serial number
serial number 33 of the daily list of,
today.
no, not today, last week, list of the last week.
All right.
But my lord, this matter does not reach up to your hands. Please, my lord,
Yes, we'll do
put
so.
this matter at the top of the specially fixed item of this week and please give me relief, my lord.
All right.
I am
Please,
76 years.
please give the letter.
I am 76 years old widow, my lord, have been
Yes,
suffering from various old.
We'll do something.
My lord, the new application, the applicant is NRI, being only purchase a property during financial year 14-15.
New application you please give. It will come.
Lord, may I be permitted, Lordship? My lord, item number 122.
Ah.
My lord, it's a pond. Lordship was kind enough to direct BL and LRO to file a report. During the pendency of the report, my lord, they have decided to construct. An advertisement has been published, my lord. We are apprehending, my lord, multiplicity of suits and proceedings will be there, my lord, in the event of prospective purchaser, my lord, the shop room and other things. They have even, my lord,
Let us see.
122.
My lord, I am mentioning one urgent matter for upgrading it.
Yes, please call the list.
Appellate side, daily listed matters, item number 1.
May I please, your lordship? I beg to upon your petitioners.
Yes.
My lord, I happen to be one of the petitioners I should be submitting because I wanted to be added as one of the additional party. I'm also a student. I also want to join in that particular petition.
And this is that nursing college matter.
Yes, your lordship.
Now,
Well,
what
there was a
happened?
direction upon my client to appear in the court today.
Hmm.
He is present. That is my duty to
Very
intimate.
good. And what is he doing now?
Now, Lordship, may I place my case if your Lordship allow? He never intended to open a nursing college. He did not run any nursing college. Lordship, what he used to do is this CAMS college. Possibly he was at fault by giving the name CAMS college. It's not a college. It is a coaching center, as well as they used to arrange for the admissions in the colleges in Bangalore. That is the situation. And which that college is known as Alexander. That college is made a party here, party respondent. That is Lordship respondent number 10. That is CNK College and School of Nursing. And my learned friends, clients. Now, Lordship, my instruction is that all of them, they have already been passed. Their results have come out. And one of the petitioners, 7 of the petitioners, they have already qualified in the courts from the Rajiv Karnataka nursing examination, which is taken in Bangalore, and as well as from Rajiv Gandhi Health University. Now, Lordship, these results are there with me. And one of the petitioners, he left the courts, that is petitioner number 8. He left the courts. Lordship, these are the things. In the meantime, Lordship, one FIR was registered against my client and he was arrested for a few days and he was detained, and that investigation is presently going on. Now, that is the fault of my client, Lordship. That's he is present in the court. He can explain. He never wanted to form any nursing college, never run any nursing college.
Now, this person who is present is
Mitropada Ganguly.
Huh?
Mitropada Ganguly. Respondent number 11.
And what about this Jia Ibrahim and Sahid Ali Chaudhary?
That is CNK, Lordship.
Respondent number 10.
Respondent number 10. I don't know. I'm not appearing for them.
Your client is
serial number 11. And their degree is valid degree, Lordship.
No, but then why do you say it is a nursing college?
Lordship, it's a CAMS college. Now, Lordship, that may be the.
See, how can you run an institution saying that you will procure admissions for an institution? Then you
cannot be. I have advised them not to do.
You're acting as a broker.
I have advised them not to do it.
My,
Let them file an affidavit. Let
They
the
will
11th
file.
respondent file.
affidavit to that.
Yes, Lordship.
my lord, there are few things that should be brought into the notice of this honorable court.
You are intervener.
Petitioners, your lordship.
You're for the pity, yes.
My lord, the thing is this, on last occasion, there had been a direction of submitting opposition, as your lordship has right now just observed. My lord, there's something new facts to be incorporated in this petition. There was a direction of putting seal to the running institution, which was been acting as nursing college. My lord, that particular institution has been put under lock and key. It has been sealed. It is just after the passing of of the last day's order, the entire seal has been removed. It has been colored, and now the entire property is being appearing as if it is a private property. My lord, there was an absolute clear direction that it should be kept under lock and key. My lord, that is not being observed. People are residing there during the night. Lights can be seen from the backside of the institution.
You are not concerned about the property. You are concerned about a fake institution being run in the property.
My lord,
If he says that he is not going to run a college, he will file an affidavit. We will issue a direction based on that he shall not run any institution without obtaining approval. And how do we prevent a private person from enjoying his property?
my lord, the thing is this, what I'm more concerned about is the certificates. The certificates and everything is within the possession of the college institution. It is well inside the property. We are anticipating that maybe the documents of the students may be destroyed in that fashion.
No, that will be directed to be returned to the students. Now, out of 8 petitioners, what your friend says is 7 have already qualified. Certificates, past certificate has been issued. 8th has discontinued or left the course in the middle, 8th petitioner. So they will return all the certificates to the petitioners and we will ensure that they don't run a nursing institution. That's it.
Actually, my instruction, we do not have anything else with us. These are all from the college. If at all anything is there.
No, if you have already taken their credentials, say such as 12th standard certificate, conduct certificate, transfer certificate, etc. All those original certificates.
These are retained with the college, original college in Bangalore.
So you are the person who has collected it.
That
yes. So therefore, he shall ensure that the certificates are returned.
Whatever is possible from our end, we will do it.
Yes, you need to. You need to do it.
And Lordship, possibly this respondent number 10's presence is required.
Gia and silent. Just Gia and silent.
Earlier occasion, your lordship directed to my lord to be present personally, probably respondent number 10, the 2 colleges. They are saying, my lord, they will appear today. But I don't know whether they are appearing today or not.
That is that GI.
I am appearing for the state respondents. I have already filed, my lord, the 3 reports in respect of.
No, the direction in the last hearing, the direction was to the inspector in charge, Bankura police station, to secure the presence of Jia Ibrahim and Shahid Ali Chaudhary. Are they present? No.
My lord, they are not present, my lord. Your lordship directed earlier occasion, someone is appearing for them.
No.
They said, my lord,
11th respondent is appearing.
that is Mrityunjay Gangu. Mittupada Gangu. And my lord, the other 2, my lord, someone is appearing for them earlier occasion. And my lord, probably, my lord, your lord, they have, my lord, they are saying, my lord, they will appear today. I don't know, my lord, they are not contacting with us.
No, who is appearing for the 12th respondent?
My lord, it was Mr. Shumon Chakraborty, that is the erstwhile owner from whom the particular institution has been. My lord, I've just received a phone call from him. My lord, it is just, we know that Red Road has been blocked. He's unable to appear just because of that. He will be delayed. He has asked me to sort for an adjournment, but my lord, I am appearing for the students. I cannot take adjournment for him.
No, let the 11th respondent file an affidavit. Then let us see what happens.
Yes, my lord. We'll file.
And my lord, one of the most students want to participate in this proceeding. She wants to be added as a additional party.
Not required, no. We'll pass an order. We have heard this also. Learned advocate for the 11th respondent submitted that the 11th respondent is present in court. It is submitted that the 11th respondent never intends to run any nursing college in the premises in question, and all that the 11th respondent was engaged in securing admission in a nursing college in the state of Karnataka. It is submitted that out of the 8 petitioners, 7 writ petitioners have qualified, passed the course, and the institution in the state of Karnataka has also issued the necessary certificates. It is further submitted that the eighth writ petitioner has discontinued the course. The learned advocate for the petitioner submitted that after the orders were passed by this court, the premises were sealed. But as on date, the seals have been removed and the premises has been painted. And it appears that there are certain persons residing inside the premises, inside the said premises. So far as the petitioners are concerned, they voice the grievance that the 10th respondent is not a recognized institution and it is a fake institution. In the light of the submission made by the 11th respondent that 7 of the writ petitioners have qualified, we direct the 11th respondent to ensure that the necessary certificates be returned to all the petitioners, that is including the eighth petitioner. And as undertaken before this court, the 11th respondent shall file an affidavit stating that he does not propose to run any nursing college in the premises in question or anywhere else without obtaining appropriate approval from the authorities. The advocate for the 12th respondent is not present today, and it appears that there is some inconvenience for the learned advocate. In terms of the directions issued by this court in its order dated 26.
Well, thereafter, another order, your lordship
One
passed
second,
on
sorry,
17th July.
you lordship passed your.
Your lordship passed on order on 17th July when, my lord, the
Yes. In terms of the order dated 17/7/2023, the advocates appeared for Zia Ibrahim and Saeed Ali Chaudhary. However, the learned advocate is not present in court today.
Sayok A.K. Mukherjee.
The 11th respondent shall appear. Sir, please, the 11th respondent shall continue to appear before this court until further orders. The affidavit, in terms of the above, the 11th respondent shall file an affidavit clearly setting out as to that he does not propose to run any nursing institution and given an undertaking to this effect. As mentioned above, the 11th respondent shall ensure that all the original certificates and credentials of all the 8 writ petitioners be obtained from the institution at Karnataka and returned to the writ petitioners before the next hearing date.
One more indulgence, my lord. We are yet to receive the reports, my lord. On last occasion, there was a direction that the reports filed at the state should be served upon us. We are yet to receive that.
Mr. Shahid Chakraborty was appearing on behalf of Mr. Zia Ibrahim and Mr. Shahid Ali Chaudhary. We have received no further instructions on their behalf, whether to appear or not. We have already sent them an email.
No,
My lord, they happen to be the main functionaries, as it appeared on the last occasion.
Let us see.
Lordship, may I only submit that upon instruction submitting, although you will take all necessary endeavor to ensure that certificates are returned. The problem is these are in custody of Zia Ibrahim and others. Now, Lordship, those certificates they can return. Lordship, kindly there is a direction, I think, upon the IC of Bakuda police station to ensure their presence. Lordship, let
Now
that.
the advocate is reporting no instructions.
But they have not received any instruction on their part, I think. So let the police ensure their presence.
For the directors, Zia Ibrahim and Saeed Chaudhary, Mr. Shahid Chakraborty appeared. Today, what happened?
My lord, we have already sent them and we have tried to contact them, but we have received no instructions from their behalf.
Where are they now?
No instructions, my lord. They have not receiving any communications.
Have you got their phone numbers?
My lord.
But cannot the police secure them?
since they are appearing, my lord, they have already told the police that they will appear.
They are not now appearing.
And my lord, earlier occasion also on 26th, they will say that they will appear directly on the court with their advocate. And now today,
Today the advocate says no instruction.
yes, my lord, that is one.
Then
Thereafter, no communication with the police.
All right, now then police will secure them, arrest
Let
them.
them ensure.
Your lordship kindly pass such.
After we have dictated the above order, a submission is made on behalf of Mr. Sayag Chakraborty, who had earlier appeared for Zia Ibrahim and Sahid Ali Chaudhry. Today it is represented that they have no instruction from the said two persons and they are not responding to any of the calls given by the learned advocate. In the light of the above, we direct the inspector in charge, Bankura Police Station, to secure the presence of Zia Ibrahim and Sahid Ali Chaudhry and produce them before this court on the next hearing date. List on so and so date. After 4 weeks. We'll give a date.
My lord, the report, copy of the report,
Copy of
please
the
hand it over
report
to
will
us.
be given.
Report may be given us to us also, Lordship,
For what?
Earlier occasion, your lordship directed not to pass any report to any other. That's
No,
why
my lord,
I'm-
on last occasion, there was a direction to provide us with a copy of the
For the
report.
petitioner alone, you please give. The copy of the report submitted by the respondent police
Here and now I am giving.
has been furnished to the learned advocate appearing for the writ petitioners. Next.
grateful.
तीनटे बोलছে।
Item number 2.
Item number 2, my lord, I appear on behalf of the petitioner. Lord, today, my lord, supposed to report to be filed by, my lord, the Secretary of District Legal Service of the.
Lordship, sorry for
Oh,
interference.
Mr. Gupta is appearing
May I
online.
get the custody of this person, Lordship, for the day?
For the day, next hearing, he'll come.
Grateful.
He'll assist you.
Last occasion, my lord, I are pleased to appoint Kaushik Gupta for the State Legal Service Authority.
Yes, Mr. Gupta is appearing online. Yeah, what is your instruction?
My lord, since I was out of town, I am out of town, I requested the learned member secretary to appoint Mr. Konar. So Mr. Konar has the report, my lord.
This is the report, my lord.
Lord, may I come back with the.
Let us see.
This is the. Along with photographs, my lord, all the photographs are, page 4, my lord, main, report 4 and 5. 4 and 5. C2, नाम का B2. Four and 5, my lord.
Page 4.
CT9 contemplated. Original order.
appear করেছে কোর্টে বললেট Four, five, six, seven. ছবি তো অনেক ঘুরছে 12 পাতা বিছড়ে
So there is a canal, but the width is reduced. It's fully covered with weeds and shrubs and it has to be cleared. So we'll issue, which authority will clear the,
All the photographs, my lord, 6, 1 and on.
no, which respondent has to clear the,
পিছড়ে দাও ওরাই বলবে রেসপন্স হু ইজ রেসপন্সিবল ফর prior to that, my lord, the report filed by the district magistrate that they have, my lord, evacuate the blockage, but that is wrong. It is, my lord.
so we will direct the district magistrate
Yes, my lord.
to direct his officers to
Right.
ensure, or whether the sixth respondent should do it.
My lord, 6 respondents
He
execute.
is the executive engineer, water management.
Yes, my lord. My lord, both the, because of both the respondents to be responsible, my lord. Otherwise, my lord, he will shift the burden to the others. My lord, the
This
district magistrate and, my lord,
had been filed as a public interest litigation, praying for issuance of writ of mandamus to ensure the removal of debris from the stream of canal and to restore the water body at Moubizia, Moubesa, Mouza, Mouza, and ensure that the canal is maintained as such. Various orders were passed in the petition from time to time, and a direction was issued to the Secretary of the District Legal Services Authority, Ulubiria, Haura District, to conduct a surprise inspection of the area and examine the state of affairs therein and submit a report before this court as to whether there is any blockage of channel or otherwise. In terms of the directions, the Secretary of the District Legal Services Authority, Haura, has filed a report dated 9/8/2023, which is taken on record. We have heard the learned advocates appearing for the State Legal Services Authority. The operative portion of the report, it is seen from the report that the Secretary of the Legal Services Authority, District Legal Services Authority, accompanied by the chairman of the subdivisional chairman of the SDLSC Ulubiria, conducted an inspection of the area in the presence of the writ petitioner along with police assistance. The Secretary of the District Legal Services Authority has also interacted with the local residents who have confirmed that there was a canal in existence and its width has been reduced. The operative portion of the report submitted by the Secretary DLSA Haura reads as follows. Page 2, sir, from here to here. In the light of the report submitted by the Secretary District Legal Services Authority, the stand taken by the district administration that the canal is in existence in a proper form is incorrect. Therefore, we are inclined to issue appropriate directions to the district magistrates and the other authorities who are in charge of maintaining the canal in an appropriate manner. Accordingly, there will be a direction to the second respondent to immediately issue necessary orders to the appropriate authorities under his command and administration to ensure that the entire canal is cleared of all the weeds, shrubs and sediments, and wherever illegal constructions have been put up, the same should be demolished and the canal should be restored to its original position. The above direction be complied with within a period of 12 weeks from the date of receipt of the server copy of this disposed of. Yes, sir. Thank you.
Lordship has disposed of this one.
Dispose of it.
May I humble submission, Lordship, can I keep it this?
Not required. It will never come. For the next 15 years, it will never come. This is sufficient. Yes.
Item number 3 to 12.
Grateful, my lord.
May it please your Lordship.
Yes.
Lordship, item number 3,
Item
Lordship.
my lord, I am for the petitioner, my lord. My lord,
3 ton one.
My
3 ton.
For ascertaining whether pleadings are complete or not.
Yes,
My
yes.
lord, that indicated on the last occasion that on 17th, my lord will be taking up these matters. My lord. On that day, the contempt applications have also been made. My lord.
Thank you, sir. May I tell Lordship?
Your Lordship, I am appearing on behalf of the State Election Commission.
Yes, yes.
My lord, Advocate General is not here today, my lord, but my lord, may I tell you, Lord? My lord, there are, my lord, total, my lord, it appears up to item number 27.
Yes.
Now, my lord, today, my lord, it fell from your Lordship what my Honorable said, that practically, my lord, today is the date fixed, but to ascertain that
Yes,
whether,
so
my
that the
lord,
pleadings are complete.
pleadings are complete or not. Now, so far, my lord, the state is concerned. If your Lordship kindly have a look this chart, my lord, just my lord, to ascertain that the position of the matters up to 1 to 27. Now, my lord, we have prepared this chart because of just to ascertain by my lord that so far item number 3, the first item, my lord, kindly have a look the right hand column, the list of documents. Now, my lord, there the my lord opposition was already filed. My lord, supplementary opposition also filed. Now, my lord, this matter, my lord, almost complete. There's nothing. Then lordship kindly come to item number 4. Here also, my lord, the only difficulty is that if your lordship kindly come to right hand side, serial number 3, one can they file. We issued a letter on 9th August that the can has not been served yet. And can 2, can 3, both. Now, my lord, in that matter, Shubhendu Adhikari matter, now, my lord, we have issued the letter unless and until it has been served upon us.
What is the prayer in that can?
My lord, prayer, we don't have, that is why, but they have filed this can.
Chakravarti, you are appearing in item 4.
Lord, the can, Lord, I appear in item 4. Lord, the cans, perhaps, Lord, the election commission, Lord, perhaps file the can. Lord, we have not filed, taken out any application.
No, we have not
Lord, it
filed
is-
any can, your lordship.
Can application.
Eight, sir. All of you, if you start talking, we'll release the matter.
Difficulty.
Lordship, Mr. Chakraborty may not be aware. I'll just indicate I am the advocate on record. Lordship, item can number 2 and 3 are perhaps intervention applications. I have been served copies. Can number 4
Very good.
on number
My lord.
4 is by the.
My lord, now, my lord, kindly come to my lord, next item number 5. Now, my lord, here, lordship, it appears that opposition ready, that means we shall file opposition today. My lord, opposition, we shall file it. Now, my lord, the copy also, sir, my lord, the item number 7, if your lordship kindly come to my lord here, my lord, the full-fledged report against serial number 5, right-hand side, full-fledged report, that also, my lord, pursuant to my lord's order, my lord, I'm very sorry to say, my lord, we shall need, my lord, another 1 week time, and we shall complete it. That is that full-fledged report, my lord, and my lord, opposition ready. But the report, my lord, we are seeking.
Wherever opposition is ready, you will serve it today.
Yes.
And so far as
Yes.
item number 7.
Now, my lord, so far,
Full-fledged report alone. you
full-fledged report, my lord,
require
we are
some time.
seeking some time, my lord.
My lord,
at least
in
1
item
week.
number 7, I am for the petitioner, my lord, but a huge time has already passed, my lord. In the exchange of reports, my lord,
All right.
we need to understand that what the
Now,
treatment
my
has
lord,
been
so
given.
far, item number 8, my lord, opposition ready, we shall file it today. Item number 9, my lord, opposition ready, we shall file it. Copy the book. Copy the book. Now, my lord, this just, my lord, to cut short the matter. Now, my lord, this so far, item number 11, my lord, copy served only on 11th of August. My lord, so, my lord, we need at least 1 week
No,
time.
if suppose the allegations are similar to the other.
Almost similar, only thing, my lord, to some extent, my lord,
Appears
one,
for item 11, WPA 386 of 2023, Gautam Sardar.
yes, my lord, some specific allegation or some
No,
specific.
in certain cases, they say everything is wrong.
Yes,
In certain cases, they have said a particular booth
particular,
or a block
my lord.
where they have said that the ballot boxes have been taken off, ballots were strewn
True.
outside. There are specific allegations. If in item number 11,
My
can you get that file, item 11? If there is a general allegation or separate.
না একসাথে দিয়ে দেবো এখানে, তাহলে সময় লাগবে, অধৈর্য হয়ে যাবে। একসাথে দিয়ে দেবো এখানে।
All right, what we'll do is we'll start hearing the matters where the pleadings are complete. Then we'll see if necessary, you can file your.
My lord. Now, in this way, my lord, it appears that, my lord, in 3 or 4 matters, my lord, since either, my lord, the copy served just 3 or 4 days back, so we, my lord, could not get it ready.
All right. Now,
Or in all other matters, my lord, whatever the affidavits which are, we could not file, but it is ready and we can file it today, and copy also we shall serve.
So far as item number 15.
And my lord,
is yet to be admitted by your lord.
and my lord, kindly come to, my lord, the list from item number 17 to, my lord, the rest of the Item 17 to 20 and item 24 to 27, my lord, no copy of the writ petition has been served. Even not even available in Sarto.
See, item 11, it is only a general prayer
My lord.
to, quash the entire decision with regard to the elections of the 3-tier gram. So therefore.
So not
required.
necessary, not necessary.
So with the available pleadings, we'll.
My lord, my lord, only thing, Lordship, my lord, wishes, my lord, to draw your lordship's kind attention to item 17 to 20.
But items 3 to 12 have been called out. So 17
No, no,
has
I
not
mean,
yet been called out.
Sir,
Sir,
confusion.
sir.
Confusion.
Item 3 to 12.
3 to 12 has been called now.
Very good. And my lord, 12 also, my lord, no copy has yet been served, and that is why, my lord, it is not ready.
12 is a contempt application.
No, in which is that order we said we'll list it today for.
আগের অর্ডারটা বললেন যে
No, on 24th of July, we passed an order.
Lordship, those were passed in item number 4. The analogous order.
Oh, there is a this is a recalling application. Recalling application. Yes, it's recalling of this order.
No matter.
Analogous.
Oh, yeah, so matter.
Tag code.
All right. Sir, please take down. In terms of, we have heard the learned advocates for the parties. In terms of the order dated 24/7/2023, in a substantial number of matters, the pleadings are complete. The learned government council points out in certain writ petitions, the copy of the stay petition has not been served. Wherever it has not been served, the learned advocates for the writ petitioners shall ensure that the copy of the writ petition is served on the office of the learned government pleader as well as on the learned standing council for the state election commission within 3 days from date. Full stop. List the matter on 17th.
My lord,
My
we have filed the opposition, my lord. In this regard, if necessary, we will file the reply, my lord.
Yes, ma'am.
Because, my lord,
We have also filed the reply
reserved our right, my
against
lord.
the-
Wherever, no, the learned government council submitted that affidavit in opposition is ready in several of the writ petitions and it will be served on the respective advocates appearing for the writ petitioners. The writ petitioners are at liberty to file a reply if necessary. Full stop. List the matters on 17.
My lord, so far as my lord can 6 of item number 3, my lord, it is a complete violation. I have filed this can 6, my lord. It's a complete violation of my lord's order dated 12 July, my lord. Already votes are called, my lord. And my lord, what my lord ordered, my lord, can we go through the can 6, my lord, once? My lord, let them file the reply, my lord. We have served, my lord. Let them file the reply on 17, my lord. So far as the can 6 particularly, my lord, it's a extension petition.
Can 6 of what?
Can 6 of 339. Item 3.
It has not been.
My lord, in respect to
Can
item number 7 also, my lord,
I will serve in the course of the day.
Can 3 in item number 3, not
Can 6.
can 6,
Can 6,
Not-
in item number 3.
not yet served.
We have already been served, my affidavit service is there.
No, can 6, 7, 8, what is the prayer?
Prayer, my lord. Can 6, my lord, can you go through?
You
that?
just read the prayer, sir.
Can 6 देखा लिखा नहीं हुई
Madam Secretary, petitioner appellant, therefore mostly humble praise your lordship may please to issue the extension of interim order dated 12 July 2023, my lord, passed by the lordship.
What is the necessary?
Because my lord,
What is the
But
extension?
my lord, they are forming the ports, my lord. This is the complete violation. of
No,
the
no.
my lord's order.
No,
No,
separate
no,
application.
this is not violation of my lord's order.
If you don't want to argue the matter, you please.
Yes, my lord's order.
We will,
That whatever steps have to be taken, that will abide by the result of my lord's order.
If you don't want to argue the matter, please inform the court. We'll delink your request.
Lordship,
My lord, with respect to item number 7 also, may I file my lord the affidavits one after another, lordship? If you,
Lordship, if you
No, no, you
or
file
my
it.
lord, may I file it, my lord?
File it. You
My-
ensure that copies are served.
My lord.
Unless copies are served, how do you obtain? No. How do you obtain acknowledgement?
No, copy, my lord, we shall serve my, accompanying a letter to them.
You serve that, you keep the acknowledgements ready. On the next hearing date, there should not be any complaint.
That's
We have not
My,
received.
that
it.
is why, my lord, otherwise, my lord, we
in
normally follow that in court, my lord, we hand over it. But today, my lord, we have decided, no, by way of my
Or
lord,
you
with
can do
accompanying
one
a
thing.
letter.
You can obtain their signature in this affidavit in opposition itself.
My,
You hand over, you wait for some time or take them outside, one by one, let them come receive it,
my.
sign, thereafter you file them.
My-
On the original?
No, no.
Original.
Original.
Lordship,
On the original. On the original.
Then on the
My-
next day,
my lord,
file
may I-
the originals with
my
the
lord, may I-
files of the court, my lord.
What is Yes. Or in your copy. you
Yes,
can-
yes, yes. Normally, in our copy, we do it. My lord knows this.
Clumsy, my lord, for-
In our copy,
Lordship-
we shall do it.
Lordship, item number 4. Item number
Lordships.
4, Lordship, my replies are ready to the oppositions filed by the state and
You file.
Your Lordship, in
Lordship,
item number
item-
6, I had taken leave
So
to
they
file
can
these
even-
affidavits and these have been served
They
also.
can-
So if I can just place it on
Yes.
record.
Lordship,
From
Affidavit
item
will
6, they are filing an affidavit.
I have served it also. Lordship, item number 3, there is a application by the state.
You start arguing the matter.
এটা পরে দিয়ে দেবো। আরো 3-4টে আছে, পরে দিয়ে দেবো।
My lord, only one thing.
Grateful.
My lord, item number 12, my lord, is a contempt application, my lord. तुम किसको इसका दिया, तुम mark करके रखो, you have a note on this day, we file.
All right, take advantage of that. That's it.
Lordship, in item,
You argue the legal issues, sir. You argue the legal issues. If you don't want us to hear the matter, you please tell us. We are very, very happy to, because other people are all waiting. We'll just delink these matters and say adjourn sine die.
Lord,
Do that. If you are willing to argue the legal issue, please argue the.
Pardons me, my lord, in item number 15, they have not.
15 not yet called.
sir,
15 not yet.
Lordship,
Everything is
in
Always.
in item number,
Everything is called up to 27.
Oh, no, then, my
Lordship,
lord,
in
may I-
item number 4,
My lord, may I tell, lordship, my lord, item number, my lord, lordship, kindly, my lord, consider item 17 to 20, and then again, item 24 to 27, no copy has yet been served.
23 copies of my lord, contempt application.
All right, if you got an extra copy, why don't you serve them? These are, they say it has been served. Where did you?
I do not know, because
Show the acknowledgement.
the copy to be served in the office of the GP, then we, my lord, get a copy from the office of the learned government payer.
Then it can't be heard on.
Is it,
17.
that is true.
Then it
But
can't be
they
heard
have,
on 17.
they have filed,
Lordship,
but no
there
copies
is a
are.
procedural aspect in item number.
Only then what we'll do is we'll hear only the matters which are ready. That's
My
it.
lord.
Lordship, item number 4 is ready only with respect to this. They have filed a dismissal application. There is no order for an affidavit in opposition.
Not required, sir.
Lordship.
Item number 12, my lord. My lord, item number.
I don't know how, when are you going to remove all these shackles and address the court on the legal issue?
My lord, item number 12, my lord, is a contempt application not yet been taken up for in all
Yes,
these
yes, it
matters.
won't
Not
be
yet
taken.
served also the copy.
Contempt application served.
That is ঠিক আছে, ও এখনো হয়নি।
The Learned Government Council submits that in several of the petitions, copies have not been served. The learned advocate appearing for, you are at 23, no?
23, man.
Total 23,
In respect of item number
In respect of item 23. submit
27 total.
That copy has been served. We fail to understand as to why the learned advocates appearing for the parties are unwilling to address the court on the legal issue. So, however, we observe that wherever copies have not been served, it's the duty of the learned advocate for the petitioner to ensure that copies are served not later than day after tomorrow, 16. list the matter on 17th.
Your Lordship.
We make it clear that,
submit.
the court will start hearing the cases where the pleadings are complete on the next hearing date.
Your Lordship.
My lord, may I humbly submit?
Your Lordship.
On last occasion, pursuant to para number 19 of the last order, my lord, has asked me to appear as an intervener in all the matters, my lord. I have served the copy. I have the receiving from the concerned departments as well.
You argue the legal issue.
My lord, along with anything that's there, my lord, may kindly call for a report from the BDO in my constituency, my lord.
Please call the next.
Your Lordship. Your Lordship.
কপি দেওয়া হবে চিঠি
No direction.
Copies has been served, Your Lordship.
All right, all.
Your Lordship,
No point.
Yes.
Your Lordship, may I humbly submit?
Apropos your Lordship's order, I want to ask, kindly pardons me, in item number 15, apparently there is no direction for affidavits. If the same affidavit, because it's a specific issue regarding a particular block. If an affidavit comes, we can also come with our rejoinder. The state has already filed an application, saying that in terms of Article 243O, this writ petition is not maintainable, an election petition should be filed. That is their state stand.
Therefore, you argue the legal issue.
But only this much.
Seat on the legal issue, then we'll see.
Kindly, your Lordship is.
Otherwise, we can never hear these.
I understand. But if they don't intend to use an affidavit, they don't intend to use an affidavit to the main writ petition, it seems. But there is no direction according to them.
Your Lordship.
There is no direction, no affidavit is ready. Well, then, my lord, if your lordship, then, my lord, we shall file an affidavit. It will take some time. That is one of the time.
Your Lordship.
18, 19 and 20.
Your Lordship, as per item number 22, we have served already. We want to file a supplementary affidavit that was also filed and served. The affidavit of service and copy of the court, we want to submit
We are
today.
not fixing these matters on a particular day. Let all the matters affidavits be ready. All of you come and then say, then we will.
No.
I think that we think that
No,
that is the best option.
Not that. Not that. As it fell from the Honorable the Chief Justice, where pleadings are complete, the matters should be hard. I was just wondering, my matter also can be also
Can you
tagged.
not make submissions on the legal issue?
Yes. That is, let it kindly pass an order, we'll make the submissions. Insofar as 15 is
There's no
concerned.
necessity to pass an order.
Please take note. In spite of passing the above order, several of the learned advocates for the writ petitioners have been continuously mentioning, stating that there is no direction issued in certain cases for affidavits to be filed. And there is allegation by the learned government council that copies have not been served. We fail to understand as to why the learned advocates are fighting shy of arguing the legal issue, which has been raised in the writ petition and opposed in the affidavit in opposition filed by the respondent. Therefore, we adjourn the matter to 24th August on the said date, unless and until all the learned advocates fully agree that the pleadings are complete. The court will not fix a date for hearing. List the matters to up to 27 on 24th August. Next.
Your Lordship, may I mention?
Yes.
Yes, Your Lordship, may I mention with respect to the State Election Commission?
Yes.
We have filed our affidavit in oppositions in most of the matters that were appearing on the 24th of July.
Let us see.
Yes, and yes. And wherever the petitions are missing, we will contact us. Then there is a direction also by Your Lordship, and we will try to communicate with the petitioners' advocates.
Item number 28.
Grateful, Your Lordship.
Indicated that after a specific.
Nothing can be indicated.
20 times.
Why are you worried?
20 times for the petition, madam.
Yes.
They are constructed.
I have filed one can application, my lord, for recalling the order which was caused for the imposed upon me.
Item number 28.
What happened to your representation?
Page 26, yes, madam. Page 26.
This writ petition has been filed as a public interest litigation for
Lordship, I am for the state.
for removal of the illegal. Get that order, man.
no government land has been forcefully occupied by the
Sales order pass, my lord. Adjacent premises, my lord.
This public interest litigation has been filed, praying for a direction upon the respondents to consider the representation dated 14/6/2023 for removal of alleged construction and encroachment over a plot of land.
Lordship, may I submit in the
No, you pass an order on the representation. It is seen that the representation has been received by the authorities.
may I
Till date-
submit the report?
Till date, no written orders have been passed by the authority. Therefore, there will be a direction to the sixth respondent to consider the representation dated 14/6/2023 and pass a speaking order and communicate the same to the writ petitioner within a period of 2 weeks. from the
Lordship,
date.
may I submitting the report?
Not required. You send a letter, reply to them.
Item number 29.
My lords, this
Lord,
is from item
29,
number 3, my lords. My lord, this is
Lord.
from item number 3, please.
We are in item 29.
Lord, item number 29, Lord, I am for the petitioner, but I am also reading the same prayer as I 28. Lord, let my representation be considered because I am made allegations regarding the government canal under the irrigation department that is being filled up.
Petitioner, please take down. The petitioner has filed this writ petition, praying for a direction upon the respondents to consider their representation dated
That 28/8/2012. 22, I'm sorry. 22. Page 22 is Bengali, but I'm sorry.
what is the date?
That the representations is dated 10th of August 2022. 10th of August 2022, appearing at page 22 bottom.
10th of August 2022, alleging that there is unauthorized construction in over a canal. It appears that the representation has been received by the authorities. Until date, no action has been taken. Which respondent has?
The respondent number 6 and 7, irrigation and PWD department.
Therefore,
6 and
without going into the merits of the allegations made by the petitioner, there will be a direction to the respondent 6 and 7 to consider the representation, issue notice to all concerned, and take a decision on merits in accordance with law and communicate the same to the writ petitioner within the period of 4 weeks from the date of receipt. Next.
Item number 30.
Obliged, my lord.
30, I appear for the private respondents, my lord.
Well, in this matter, I appear on behalf of the petitioners.
My lord, item number 30 and my lord, item number 19, my lord. Related
No.
to the same plot of land, my lord.
My lord, may I submit one thing? No, pursuant to a
On
lordship,
11th July, my lord, your lordship was pleased to pass directions, my lord.
well, that order is here, my lord.
In connection with the same plots of land,
My-
my lord, by proceedings
My,
before the DM.
my prayer is very specific, my lords.
Now there is, my lord, 43 occupants in that plot of land.
So, my lord,
No, maybe 43 or 500. If suppose somebody is selling a PWD land,
his learned friends, client, my lord.
let the authority look
My
into
lord,
it.
is a kindly see the order passed by your lordships. In this matter, my lord, is another person moved an application before your lordships.
My lord, we have filed an
And there
application
is
for,
the proceeding under section 10 of the West Bengal Highway Act. And herein, my lord, he is selling the property, the government property, admittedly, one after another, my lord. I have annexed the.
All right, you file your affidavit. You file your affidavit.
My lord, kindly, there is the order passed, already authority concern has
No, no,
taken the
let the-
steps.
The official respondents who will appear for the district magistrate.
So that is, my lord, the very vital district, my lord, I have served.
There will be a direction to the
File a report,
ninth
my-
respondent as well as the respondents 12 and 13 to file their affidavit in opposition to the prayer sought for the petition. List the matter after
My lord,
6 weeks.
my lord, may I indicate, my lord?
You move that application.
On 9th, my lord, we have went to the district magistrate for hearing, my lord, in connection with that, my lord. We have specifically pointed out to the district magistrate that there are already 43 occupants there.
Let them go.
There is also
I have
State
no
Bank-
objection,
there is
my lord.
also State Bank.
My lord, I have.
No, my lord,
So therefore, if the district magistrate, please wait.
no, the district magistrate says, my lord, since the order of my lord is in connection with respondent number 8, 9 and 10 in that matter, he will not go beyond that. He will not ask anyone to come. There are 43 occupants, my lord.
He sell out.
Let the district magistrate file.
Come with the report, then my lord, the supplementary evidence annexing your lordship's order, which has
Item
been
number
passed in
31.
My lord, that may be recorded.
All right, supplementary affidavit kept on record.
Kept. Great.
Item number 31.
31,
I am for the respondent number 10, 11.
I am for the state, my lord. Who is appearing for the writ petition, my lord?
What is the prayer, sir? Restoration of a canal.
Yes.
You consider the representation. This writ petition has been filed praying for issuance of writ of mandamus to restore a canal which is alleged to have been occupied by the private respondents, namely respondents 12 to 13. Since the writ petition is being disposed of without calling for affidavits from the respondents, the merits of the allegations made by the petitioner are not gone into. And there will be a direction to the fourth respondent, block development officer, to consider the representation. What is the date of the representation?
My lord, 2nd May 2023.
22/5/2023. Issue notice to the private respondents as well as the writ petitioner, and after hearing the parties, pass a speaking order on merits and in accordance with law, and communicate the same to the writ petitioner. This direction be complied with within a period of 6 weeks. Disposed of.
Item number 32.
Want some order to be set aside. Not today.
Item number 33.
33, I am for the petition. The issue before your lordship is this, my lord. My lord, the private respondent number 7, my lord. He is constructing a house under the government, my lord, housing scheme. In a, my lord, the land is recorded as a, my lord, pond. The municipal authority, my lord, initially, my lord, sanctioned the building plan. Thereafter, my lord, I lodged complaint to the municipal authorities as well as the SDO for not sanctioning any fund, as because the land belongs to, my lord, the pond. Subsequently, after receiving my complaints with the municipal authorities, my lord, issued a notice, stop work notice, my lord.
Page 19.
Yes, my lord.
Page
My
9.
lord, thereafter, my lord, even then, my lord, the construction is still going on over the pond, and my lord, the fund which has been raised by the, my lord, municipal authorities is not, ought not to have been, my lord, issued. My lord, the public money is involved here, my lord. If, my lord, on that,
Who will appear for this Bankura municipality?
my lord,
They have been served.
yes, my lord, everybody has been served, private is
We
also
will
served.
direct them to take further action.
My lord, kindly direct the, my lord,
This-
SDO
this-
Shodor, my lord, who is the appropriate authority here, my lord.
Who?
SDO Shodor Bankura, my lord.
Fifth respondent.
My lord.
By this public interest litigation, the petitioner alleges that the private respondent private respondent number 7 is putting up construction in a land which is Pukur Park.
Pukur Park, pond.
PUKUR inverted.
My lord, I have annexed the record of rights P12 for my.
It is submitted. It is alleged that the state funds should not have been allotted for the putting up of the construction in a water body. And in this regard, a complaint was lodged to the Bankura municipality, pursuant to which, by memo dated 13/1/2023, the 7th respondent was directed to stop construction. It is alleged that in spite of such a stop work order, the 7th respondent is proceeding with the illegal construction. And representations have been made to the official respondents, and in particular to the 5th respondent on 2/7/2023. and 3/7/2023. And since no action was taken, the petitioner is has filed this writ petition. Since the writ petition is being disposed of without calling for affidavits, the court is not inclined to go into the allegations made by the writ petitioner at this stage of the matter, and would direct the fifth respondent to immediately take up for consideration the representation, issue notice to the writ petitioner as well as the seventh respondent, conduct a spot inspection of the area, and proceed to take action in accordance with the law. This direction be complied with within a period of
subject to lordship,
3
corrections,
weeks.
my lord. My municipal authority is also empowered under section 218 of the municipal. My lord,
During the inspection, the officials of the Bankura municipality shall also be present. Next.
I don't know what 34. Grateful, lord.
My lord, item number 34, lordships, if you allow me to, my lord, appear online because I'm not well, I'm suffering from fever.
Very good, no problem.
Your lordship, the affidavit service is still
Conduct
not
entrance examination for admission.
My lord, I appear for the University of Bardwan. Lordships have dealt with this matter earlier.
Yes.
But your
I tell you, lordship, there is one difference. I tell you, lordship, earlier order, lordship will kindly, it comes to page 26. My learned friend has annexed that.
Yes.
Page 26 is the earlier order passed by your lordships.
University totally said that they will start it.
I'll clarify to your lordship. My lordship need not go through the entire order. Kindly come straight away to paragraph 9 at page internal page.
1 minute.
I'm sorry.
In that page number 30, para 9, we have said, the learned advocate appearing for the respondent university, that the respondent university will revert back to the old procedure and will conduct the entrance examination before finalizing the examination of the third year LLB course also for the academic session commencing 2024. This undertaking is already there.
But they are totally violated that. In also they are submitted that in course BLLB 5 years they will also start the exam, but the order was totally violated. We are again in front of your lordship. That's why only.
They will do so from the academic session.
Yes, your lordship, but the fifth year AU was launched some days before the new academic session was started. After seeing that, that's why we are filing this.
No. New academic session 2024 will start later, not now.
May I just clarify in 1 second, if your lordships allow me?
Yes, sir.
My learned friend is aggrieved with the notification at page 17 of the writ petition. This is with regard to, my lord, there are two autonomous, or there are two colleges imparting 5 years LLB course under the Bardwan University. My lord, this is with regard to a notification 30th June 2023 for the academic session 2023 to 2028. Now, my lord, my learned junior is there with another separate undertaking, which again reiterates that from the session commencing from 2024 onwards, which will be next year, 24 to 29, we shall revert back to the entrance examination. As per your lordship's order, we quote your lordship's order. This is from 23 to 28. Your lordships are directed, my lord, from 20 session commencing from 24. We shall do that. Again, a reiteration of that.
All right. But by this writ petition, the petitioner seeks for a direction upon the third respondent university, namely University of Bardwan, to conduct entrance examination for admission in the course, admission to the 5-year BA LLB course. On an earlier occasion, this court had dealt with an identical issue and had passed an order in WPA within bracket P152 of 2023, dated 17/4/2023. In the said order, the submission made on behalf of the respondent university was noted, wherein they have undertaken that they will revert back to the original procedure of conducting entrance examination for admission to the 5-year BA LLB course for the academic session commencing 2024. The petitioner has annexed the notification dated 30/6/2023, which is for the academic session 2023-28. The learned advocate appearing for the third respondent university has produced a copy of the notification dated 2nd June 2023, which pertains to wherein it has been stated that the entrance examination will be conducted in terms of the direction issued in the earlier writ petition, which was pursuant to an undertaking given by the respondent university. Therefore, the petitioner need not have any apprehension, and the third respondent university shall abide by the orders passed in the earlier writ petition.
Only one thing, possibly the date has gone down wrongly. The instructions given today by my learned junior should be dated 14th of August 2023 by the registrar of the university. I think he has handed it wrongly. Kindly excuse him and takes this. That is a government order of a separate matter. Kindly do not take that on record. Otherwise, your records will be, Lordship's records will be wrong.
14th August, huh?
14th August, by the registrar of the university, reiterating your Lordship's order.
14th August so-and-so, which reads as follows.
Well, I'm deeply obliged to your Lordships.
Deeply obliged to your Lordship.
Yes, sir.
Grateful.
Next.
I don't know, 35. Up to it, agent. Petition.
Yes.
My lord, I am appearing for the writ petitioner, but at the outset, let me submit, my lord. Service has been done, but affidavit of service is in the process of affirmation.
No problem.
Then, my lord, grateful, my lord. My lord, my locus standi is at paragraph 2 of the petition.
But I'm not opposing regarding locus standi. Let him, my lord.
Then, my lord, this is as usual in Malda Chachal Panchayat, the irregularity has been surfaced regarding grant sanctioning of the work of horticulture, allotting of job card. If your lordship kindly look to the paragraph 11, detailed irregularity has been mentioned therein, my lord. It is a short paragraph. But 11 and 12, my paragraph.
Now, no notice of meeting was served on the writ
No,
petition.
not at all, my lord. And moreover, if your lordship kindly look to page 22, the order of the Honorable Justice Shampa Sarkar.
But please, before that, please come to page 25, the order sheet.
Yes, my lord.
Of the block development officer, second paragraph.
Yes, my lord.
Whereas the petitioner so-and-so alarm was asked to appear for hearing on 13/12 and his grievance and complaint was heard on 13/12. Whereas the respondent Pradhan and secretary of the Gram Panchayat were asked to appear for hearing on 26/11.
My lord.
Statements were recorded on 26/11. Inquiry team formed for the purpose of so-and-so. Against this, why don't you file an appeal to the district magistrate? Is an appeal provided?
My lord, may I tell lordship? My lord, this, my lord, the spiel, my lord, that is, my lord, has arisen out of, in fact, the action taken by the block development officer in terms of the order passed by this court in earlier writ petition. That was, my lord, before the, my lord, where the panchayat matter is, my lord, usually, my lord, taken up. Now, my lord, in that determination. Now, my lord, in terms of, if you also kindly have a look at page 24, my lord, the operative portion of the order passed in the earlier writ proceeding. And that was initiated at the present petitioners. Number 24, lordship kindly see, the last part one, the block development officer shall dispose of the complaint and communicate the order to the parties within a period of 2 months. Now, my lord, in terms of this order, that that was, my lord, the exercise was done by the BDO, and that is the, my lord, the lengthy order sheet file. In your lordship, kindly come to the, my lord, the penultimate and the, my lord, the final conclusion. If you lordship, kindly come to page 30. Page 30, the last part of the order sheet. And whereas the opposition leader did not specify in his complaint that which tender notice he meant for, this was one of the complaints he lost, that regarding the tender. As in the complaint, no specific tender notice was mentioned, so no action could be initiated. Hence, the complaint is disposed. Entire matter has been decided independently on the basis of records, and all parties are directed to act on the basis of the sub copy of this order. Examine all the complaints put up as annexure of the writ petition. Subsequent hearing was also conducted. I cannot establish any material facts as envisaged in the complaints put up as annexure. Hence, cannot initiate any further action with respect to such allegation. That the petition dismissed. That means, my lord, it
No,
was an
if you-
incomplete.
Yes. Now please come to page 10, para E.
My lord.
Yes. Of this, of the petition.
My
Please see, this is his allegation.
No, this is, my lord, allegation, my lord, that has been, my lord, the averment made in the writ petition. But, my lord, I think and I am sure that as it appears from the order sheet of the video, that this was not mentioned, my lord, possibly it is, my lord, after that. My lord, so far this present writ petition is
cannot the
concerned.
No, no.
There are many averments which were not there.
Can you not now go, because already the block development
Yes,
officer.
my lord, I agree with you. There is a provision of appeal. As your lordship initially observed, yes, your lordship may give the direction that let the petitioner appeal before the learned district magistrate.
Because he will call for
Yes,
the file.
yes,
SDU
my
is or
The
SDU.
concern is.
That is the, I accept, my lord.
Lordship, may I submit, Lordship?
Well, I think whoever is the appellate authority, maybe SDU, well, I'm not sure. Or maybe.
Lordship, I'm appearing for
Yes.
Pradhan and Gram Panchayat, basically.
Are you sure?
Lordship, in certain allegations, video has stated by especially point to point wise. My submission by Lord, he is the leader of the opposition in the same Gram Panchayat. And he has come with a specific allegation before the Lordship Sampral Sarkar. Lordship was pleased to pass a specific direction, and that has been thoroughly complied with. My submission, Lordship, if he has any further grievances, so this cannot be the court before he should come with the.
Because we cannot, that is why we say, we cannot
Yes, ma'am.
examine the
I agree.
disputed question.
Second issue, my lord, Lordship has please noted on page 10 of, and specifically, Lordship, in BDO's direction, there is specific points. On his 6-7 points in his allegation was that in the previous.
If he is aggrieved, let him prefer an appeal to the appellate authority.
Yes.
Why do you worry about that?
The BDO's immediate appellate authority, generally, SDO is the immediate. Looks
Whoever
after
be the
BDO's.
appellate authority,
the
we will appeal to the that.
Petitioner is
Let
aggrieved
that
by
direction be passed, my
an
lord.
order.
Otherwise, they may not take
the
it.
block development officer, Chanchal number 1 development block, Maldas district, dated 8th June 2023. In the writ petition, several grounds have been stated. 8/6/2023 stated as to how the order is bad in law. On going through the, no, sir, after hearing the submissions of the learned advocate for the writ petitioner and going through the averments made in the averments set out in the writ petition, we find that many of the allegations are disputed questions of fact, which cannot be adjudicated in a writ petition. Therefore, the appropriate course to be adopted by the petitioner is to file an appeal to the appropriate appellate authority if the petitioner is aggrieved by the order passed by the block development officer dated 8/6/2023. Accordingly, the writ petition stands disposed of, giving liberty to the appellant writ petitioner to file an appeal before the appropriate appellate authority, challenging the correctness of the order passed by the block development officer, Chanchal 1 development block, dated 8/6/2023. And if such appeal is filed within a period of 30 days from the date of receipt of the server copy of this order, the said appellate authority, after affording an opportunity of personal hearing to the writ petitioner, as well as the Pradhan of the Panchayat, namely the Pradhan and Upapradhan of the Panchayat, namely the 7th and 8th respondent, and also after calling for the necessary records from the block development officer, the appellate authority shall take a decision on merits and in accordance with the law.
And my lord, notice be served also any other interesting party. There may be, my lord.
Needless to state that if the appellate authority deems it appropriate to serve notice on any other party who is likely to be aggrieved, such party also shall be put on notice.
Get put notice.
Next.
I don't know, 36.
Lordship, the standing council could not appear. I was seeking for kindly fix on next Monday
You are for the respondent.
for the petitioner.
Delimitation exercise, we can't interfere. Sir. There is a constitutional bar.
I understand that, Lordship. Kindly fix on next Monday and
When do you want it?
next Monday.
At the request of learned. You work out that it is not maintainable. We'll have to dismiss it. The learned advocate, adjournment is sought for on the on behalf of the learned advocate for the petitioner. The petitioner appears to challenge a delimitation exercise done by the respondents. The petitioner has to first satisfy the court as to the maintainability of such a prayer. 2 weeks adjourn. You work out and come.
I don't know, 37.
Your Lordship, come on the behalf of the petitioner. This is the affidavit of service, Your Lordship.
Mr. Sheikh Mohammed Ghali, appearing for the state, is not coming to the court for applying for adjournment for the day, Lordship. Duty is
I'm
personal.
representing the respondent number 6, my lord.
Your Lordship.
His clerk given information to me.
On a complaint dated 9/6/20 made to the Howrah police and others by the
Respondent, Your
petitioner
Lordship.
restrain. What is the complaint, police complaint?
Your Lordship, private respondent number 5 is operating one workshop which use a hydrochloride acid for cleaning the rust from the iron and other metals, Your Lordship, which release another life-threatening gases to the locality.
No,
And-
you approach the pollution control board.
Your Lordship, I approached the district magistrate because they are dumping the hydrochloride wastage to the drainage system of the Howrah Municipal Corporation. It's come under the DM, Your Lordship.
And you are appearing for?
I'm not, Mr. Sheikh Mohammed Ghali is appearing for the state also. He is unable to come to the, to his personal difficulties. I couldn't.
Lord, I am appearing for the respondent number 6.
6. Only 5 respondents are there.
Only 5 respondents.
5th respondent.
Yes, my lord.
Private respondent.
Private respondent.
Private
respondent.
allegation is that you are letting out this hydrochloric
Now, my lord,
acid.
the allegation, my lord, is wrong because, my lord, my client, lord, the private respondent is not running a business there, but my brother is running a business. My brother was not made a party. Maybe, lord, my submission is, my lord, that whenever the allegations have been made against me, that I am performing the jobs, your lordship kindly look to the prayer A of the writ petition, that is main servants, agents and or assignee to act according to law and forthwith take steps to no acid polishing and plating workshop. Now, lord, acid polishing and plating workshop, lord, has been withdrawn. That was there immediately after the allegation is made. I have withdrawn it.
Very good.
Now, my lord, I may start it subject to, my lord, clearance, subject to clearance from the Pollution Control Board and other statutory authorities.
Your Lordship, I have only 3 points to submit. First, Your Lordship, there must be an authorization from the Hazardous Waste Management and Handling Rule 1989. It is very compulsory. Second is that the electroplating workshop fall under the red category of the activity, Your Lordship, and therefore it is not permitted to operate in the municipal area. Your Lordship, how the private respondent will operate without the
They
pollution?
are stopped. We will stop them. If at all they want, they
Very
can
much,
start it.
very much.
Lordship.
Your Lordship.
The petitioner, by way of this public interest litigation, seeks for a direction upon the authorities to take immediate action against the 5th respondent who is operating a electroplating industry and also using acids for polishing of various metals. According to the petitioner, the electroplating industry is a red category industry and it cannot be located in a municipal area. Full stop. In this regard, a complaint was made to the respondents on 25/7/2023, and since no action was, and alleging that no action was taken, the petitioner has filed this writ petition. The learned advocate appearing for the 5th respondent submitted that the 5th respondent is not running any industry in the said area, and it is brother and it is the fifth respondent's brother who was running an industry, but as of now the industry has been closed. This aspect has to be verified by the authorities. In any event, if the industry is a red category industry, obviously without the prior consent of the pollution control board, the industry cannot be operated.
And your lordship,
Therefore, there will be a direction to the respondents 2 to 4 to immediately ensure that no such red category industry or acid or industry using acids are being run in the premises in question either by the fifth respondent or his brother or any third party. And if at all such industry is carrying on any activity, the same should be sealed immediately. It will be well open to the concerned person who intends to operate the industry to locate it in an appropriate site, and carry on activities only after obtaining the necessary approval from the pollution control board and other authorities of the respondent state. With the above observation and direction, the petition is disposed of.
very much
Next.
obliged, your lordship.
I don't know, 38.
Okay.
Lordship, I appear on behalf of the petitioner.
Hmm.
Service on my part is yet to be completed upon all the respondents. If Lordship kindly keeps it sometime next week. Pledged.
List matter immediately after service is complete
I don't know, 39.
in the admission list.
I beg to appear on behalf of the petitioner, whether
Yes.
this matter relates to the Panchayat election matter, that there is several complaint lodged by the presiding officer and other officials that has been kept pending, has not been investigated. Petitioner paid for the impartial investigation over the complaint.
Why already it is there, sir. Several cases are. The petitioner in this writ petition challenges the recently concluded Panchayat elections in the state of West Bengal and seeks for the conducting repoll. Similar prayer have already been entertained by the court, and the matter writ petitions are pending. Therefore, we are of the view that there need not be multiplicity of proceedings, but however, we grant liberty to the writ petitioners to intervene in the pending writ petitions. With the above observation disposed of. Next.
I don't know, 40.
Lord, I am for the petitioner.
Plan for the statement.
My lord, an unfortunate accident took place. A 7-year-old school-going boy who died recently in front of his school. My lord, it is not about that particular case. My lord, it is all about the concern about the guardians. My lord, my allegation is not against anyone, not even against police, because my lord, they are
taking from the newspapers. We read that police are being posted, the traffic is regulated, certain roads have been made one way, unauthorized parking has been.
Well, that is for that place only. Well, my prayer is that, but there are many schools in the states on the which are the nearest place of the roads. So,
we can't issue general directions, sir. If suppose you have got some material, you can list out these are all the schools where it is situated near the main road. Please do something. You make a suggestion to them.
That is perhaps not the prayer of this PI.
My first prayer is that to make a guideline how during the school period the traffic.
The petitioner suggest.
Petitioner suggests 3 things.
No, where is your representation?
I have not made any representations.
The petitioner has filed this writ petition, praying for a direction upon the respondents 2 to 7 to deploy proper traffic personnel to safeguard the school students from the nearby busy roads while during school time and tiffin time. The petitioner has not even submitted any representation to the authority and straight away filed this writ petition which cannot be entertained. Therefore, the writ petition is disposed of, giving liberty to the petitioner to file a comprehensive representation, making clear suggestions to the appropriate authority, which can be taken into consideration by the said authority. Next.
My lord, one line, my lord, lordship says that for the particular area I have stated, my lord, I have stated.
No,
for
not
the
particular area. School time.
Milord, the prayer here, Milord, is so vast, but Milord, the officers have worked so hard, Milord. But only one thing which I wanted to bring it to Milord's knowledge, Milord. In 2015, the fatal rates of accident was 422 per year. We have brought it down to 85. So, Milord, the actions the officers have been taking daily, Milord, despite the fact that, Milord, one of the oldest city only having 7% of the road surface area, Milord.
My lord, as I said, my
not there
lord,
in
my allegation not even against the police, because they are also the parents.
Proper suggestions.
And
Next.
they are also the
Item number
child
41.
also going to the same.
Yes. Item 41.
49.
UTP, no? Password. Next.
Item number 42.
Lordship, item number 42, the counsel appearing for the petitioner couldn't attend the court today. I'm praying for not today, Lordship.
You don't have the papers.
I don't have the paper, Your
See,
Lordship.
the problem is, once it goes out of the list, we cannot upgrade it, etc. It will go to the monthly list.
Lordship, kindly could beseech your Lordship to kindly make an accommodation today, Lordship. A single accommodation.
At the request of learned advocate for the petitioner, urgent. Give some dates, what to do.
Item number 43.
Grateful.
43. Yeah, please, Your Lordship.
I'm appearing on behalf of the respondent number 8.
What is the prayer, sir?
Prayer is the classification of land is wrongly done.
And you have filed your report.
Yeah. I'm for the respondent number. I'm the private respondent.
Private respondent.
I'm filing the objection to regarding the report.
Have you served the exception?
Yes.
None appears for the writ petitioner. The learned advocate appearing for the respondents, respondent number 8, has filed his affidavit in opposition to the respondent number 2 and 3. The said affidavit in opposition is taken on record. Adjourned. Next.
Item number 44.
44, my lord, I'm appearing for the petitioner, my lord. This is a matter, my lord, wherein, my lord, a direction for filing of opposition has been given. The state has filed the opposition. We have our reply is ready, but the Union of India is required to file an opposition because that is important in this matter, my lord.
Who has to file it?
Well, Union of India has to file. Mr. Bilodal Bhattacharya, the DSG was appearing, my lord, in this matter, my lord. And my lord, if your lordship, my lord, directs them because that is required. Otherwise, this matter.
But there was already a direction for them to.
Yes, yes, there was previous directions for them. Lordship will kindly cease, ma'am. Union of India.
Anybody will appear for the Union of India?
Yes, Mr.
Deputy Solicitor General was appearing.
Exactly.
The advocate says that your affidavit is required in the matter.
Reply is required. Opposition required.
Which is the respondent?
Well, he is the respondent number, my lord.
The 12th respondent.
Yes, yes, ma'am.
Joint Secretary, Ministry of Agriculture.
Yes, ma'am. Minister of Agriculture.
The 12th respondent or any other competent authority of the Ministry of Agriculture, Department of Animal Husbandry and Fisheries, New Delhi, is directed to file their affidavit in opposition within 4 weeks from date, and the copy be served on the learned advocate for the petitioner, as well as the learned government council appearing for the state of West Bengal. Reply, if any, within 3 weeks thereafter. 4 plus 3, adjourned. 45, 46, what is this?
I don't know, 45 and 46.
Item number 46, my lord. I'm appearing for the petitioner, my lord. If your lordship kindly come to the order dated 13th March, my lord. there were direction, my lord, and my lord, on the last occasion, my lord, the learned advocate for the WBSCDCL was supposed to file a report, my lord, and we have not received any copy, my lord.
What is WBSCDL?
My lord, West Bengal State Electricity.
Oh, electricity.
Yes, I am appearing for the WBSC DCL, my lord. There is, my lord, committee was constituted, headed by the district magistrate. They have, my lord, asked a report regarding the street street light. Accordingly, we have submitted the report before the district magistrate, and we have also last occasion a copy of that also filed here, my lord.
My lord, we have not
File
received,
and-
my lord, if your lordship.
Yeah,
kindly-
I shall give you.
All right. My lord, and my lord, if your lordship kindly come to the order dated the 30th January 2023, my lord, there was a, we have submitted, we have made our submission that regarding the, my lord, my lord, victim of Degonga incident and my lord, victim of Basdori incident, my lord, they have not received any compensation, my lord. Salsa,
The state.
my lord, Salsa supposed to be appear and made their submission, my lord. If,
No, which district they have not received?
my lord, Degonga and my lord, Basdoni. Those victims have not received any compensation, my lord. Till date, my lord, we have not information, my lord.
Deganga, the report says that the application of so and so is pending for disposal. And other one?
My lord, Basdoni, my lord.
Anybody is appearing for SLSA?
My lord, Mr. Parindam Sen and Sagnik Bhattacharya is appearing, my lord, for the Salsa, my lord.
But today they are not there.
My lord.
My lord, I am online, my lord. If your lordship directs me, then I can take necessary steps.
You please file, it's some compensation which is pending. The earlier report of the member secretary filed on 24th of January. They have stated that wherever the payments have been made, the advocate says in respect of in 2 districts.
My lord.
In 2 districts, compensation has not been paid. We have heard the learned advocates for the parties. The district magistrate has filed a report on the earlier occasion. Let a copy of the said report be furnished to the learned advocate for the petitioner in WPA 142 of 2022.
My lord.
142.
142, my lord.
Of 2022. The learned advocate appearing for the SLSA is directed to get necessary instruction and a report be filed by the SLSA as regards the status of the applications which have been filed praying for compensation.
Okay, may I have a kind indulgence, Lordship? A similar matter.
Yeah, my lord, my junior is there, my lord. My lord, there is a connected matter with regard to victim compensation. If it can be tagged with this, my junior is there, my lord, can hand over the slip.
Let these requisitions be tagged along with WP. WP 17397. No, this one is challenging the various clauses in the scheme.
Yes, my lord.
Why we should tag this along?
My lord, because when the victim compensations are disbursed, my lord, the challenge to the scheme is also becomes vital because the amount and the way it is disbursed is altered, my lord.
As of now, the scheme is operational. Government has been sanctioning funds. Monies are being paid. If they want, let them move the requisition. Don't tag it.
Very well, my lord. Very well.
Move it. We'll come back after 10 minutes.
Next matter, my lord, 47, my lord, only praying for 3 weeks time.
I am for the petitioner, my lord, in
For
this
extension
matter.
of time to file affidavit, my lord.
Because his affidavit is required because he appears for UGC. However, there are adequate, sufficient evidence to show that this person did not possess the requisite
Item
qualification.
47.
Lordship, item 47, I am appearing for the respondent number 4, 5 and 6, Lord. That is the university, Lordship.
My lord, I am
There is a direction to file affidavit in opposition that may be extended, Lordship, that we are.
Time for filing affidavit.
my lord, I am praying, Lordship, I am appearing for
Lordship,
the
there was a
private
direction
respondent,
passed
my lord.
up
May I be
1
allowed
year
to file?
back.
By
I am
the
praying
On
for extension of
23rd
time.
August.
3 weeks
That's
from
right.
date.
3 weeks time I am
copy of
praying
the,
for one.
affidavit
For
in
extension of
opposition
time.
be served on the learned advocate for the petitioner. The affidavit in
Yes.
opposition
Lordship,
on behalf of
There was a direction passed after.
on behalf of private respondent number 7 has been filed, copy of which has been served on the learned advocate for the petitioner. Liberty to file a reply if need be.
Now, Lordship, for the other affidavits, Lordship, the direction was passed on 23rd August 2022.
We will extend it by 3 weeks.
Yes, Lordship.
Lordship, and kindly fix it after that, Lordship.
Yes, we will give a date.
And let it come on top of the list on that day. Lordship.
Daily list.
Lordship,
Lordship, the petitioner have, the private respondent have already retired, Lordship, in the month of
Lordship,
March,
That
Lordship.
doesn't matter.
Lordship, item 48 and 49, I am praying for accommodation because Mr. Gupta has not come. I am appearing for the West Bengal Board of Primary Education.
So far as item 48 is concerned, well, the CBI is supposed to file a report. But this is
Kindly,
a
Gupta is not available.
Mr. Gupta is not in the court, Lordship.
All right. How many?
Lordship, any day, next week, any day, Lordship. Any day, Lordship.
Item 40, 48 and 49, next week. You give a date.
Grateful, Lordship.
is here, my lord.
What is that report?
But the CBI, on the last occasion, my lord, your lordship directed the CBI to file a report stating whether
Let the report remain with the DSC. We will take it up on next week.
Grateful, Lordship.
the report basically indicates
Lordship is fixing on some,
we are conducting the investigation holistically.
Lordship is fixing some day, Lordship. Lordship,
Next week.
grateful, Lordship.
সামনের সপ্তাহে
Appearing on behalf of the state, my lord, the learned AG is not in court today. He had indicated, my lord, if adjournment could be granted. My lord, pleadings are complete in the matter.
Pleadings are complete.
Pleadings are complete.
Lordship, exceptions have been made, exceptions have already been served, my lord. So this will be taken on record. I am from the petitioner, my lord.
We have heard the learned advocates for the parties. Exception has been filed by the petitioner. So the affidavit filed on behalf of the state respondents. Copy of which has been served on the respondent state. It is submitted by the learned advocate appearing for the state that the learned advocate general is not available today and adjournment is sought for. After 2 weeks,
14th, 22nd would have been better, my lord.
Orange on the first day of September.
we come on 22nd. 22nd, 22nd.
22nd. Grateful, my lord.
Yes.
I don't know, 51.
And I'm for the petitioner, my lord.
Yes.
My lord, this exception was to be filed by me against the report of the state.
What is the
The
matter?
matter is with regard, my lord, the mother of the petitioner, she died. She was murdered, my lord. It was alleged that the ruling party, members of the ruling party has committed the murder, and the investigation was, the postmortem was subject, they challenged the postmortem. The second postmortem was conducted, my lord. My lord, the second postmortem was conducted by the order of this court, honorable court, my lord. Now, the state was asked to preserve the body. My lord, when the second postmortem was to be conducted, they found the body to be decomposed and it could not be identified by the family members, my lord. For that reason, they did not identify the body because it was totally decomposed. Not despite there was an order that the body was to be preserved. But it was at that stage they conducted the postmortem and they filed a report before this court. We have filed an exception to that effect.
All right, where is the body? Cremation is
No,
over.
my lord.
You take the body and do the cremation.
My lord, since the family members are saying that the body is not
The body is in a decomposed state. You can't do anything with that.
my lord, but
Therefore, you accept
my
it.
lord, we have experience, my lord, that in a similar matter, my lord, the body which they are giving is not that of the family member. There has been an instance with regard to a child's. The child went missing, and then they said that it was that the baby was
Imagine the plight of the mortuary.
my lord, but the family members are saying that, madam, because they were also ready to take, my lord.
Something
My lord, can we pray, my lord, that if DNA can be done, my lord, DNA test, my lord, because they are saying that it's upon instruction, my lord, I am submitting because
Who will appear for the state?
my lord, earlier Nilotpal was Mr. Nilotpal was appearing, my lord, but after that earlier he was appearing, but right now he's not in the panel.
The AGP is there, Mr. Mahata is there.
Report Chatterjee is not in the panel now, my lord.
Mr. Siddiqui was there.
Oh, Saleh is still there.
Then, my lord,
Siddiqui and Mr. AG, learned AG appeared in
AG is not available
yes,
today.
today he's not.
Mr. Siddiqui is there.
Mr. Siddiqui.
The learned advocate for the petitioner shall inform the learned government council appearing in the matter that the case will be taken up on 22nd. 22nd.
But only the supplementary affidavit.
Supplementary affidavit is kept on record. Next.
I don't know, 52. Lordship 52. I am for the petitioner, Lordship. This matter, Lordship, as per the last direction, there was a problem with the service. And lastly, the panchayats has been solved. This is a matter regarding dredging of canals in the East Kolkata wetland region. Lordship, the story here is, Lordship, on 17/11/2021, a meeting was held, Lordship, where the petitioner was been involved. Now, Lordship, I've sought a copy of the minutes. The minutes was not supplied. Now, come January 2022, a survey was being done, Lordship, for dredging of the 17 canals, Lordship, in the East Kolkata wetland region. 2 canals have been surveyed, Lordship. One is Bidadhori 1 and Tihuria. After which, Lordship, a complete silence. What has happened in the survey? Nothing, Lordship. Now, suddenly come May 2022, Lordship, dredging work started, Lordship, and which started in the most unscientific way, and it was a complete mayhem, Lordship, and a total destruction of the life and livelihood, Lordship. Lordship, page 31. The photographs are being annexed, Lordship, how the dredging has been done. Starting from page 31, Lordship can see page 31, page 20, page 32 also, Lordship. Trees have been felled, Lordship. These are, Lordship, this is how the dredging has been done, Lordship. A complete mayhem, Lordship. Total loss of life and livelihood. And Lordship, page 30, Lordship. If I can take my Lordship to page 31. This is how a proper dredging is being done, Lordship. Dredger has to be put down on the waterbed, and this is the how a proper dredging is to be done.
But if suppose in the canal,
My lord, these are the photographs.
Sufficient water, then the dredger cannot be put into the water. It has to be on the banks. So only an excavator can.
What has been done, Lordship? Lordship has seen page 31 and 32, Lordship. What has happened, Lordship, if the dredgers are being kept on the bank, Lordship, complete loss of life and livelihood.
No, it's not a dredger, it's an excavator.
Yes, Lordship. And excavator was being put to
See
use.
the water level in page 31.
Lordship, I've seen that, Lordship.
The dredger can't enter.
No, Lordship.
And one more thing. See, these are all technical matters. You give your suggestions, we will direct them to constitute a team.
Lordship, page 27 once, Lordship. Now, how it has been done?
Photographs. No, based on photographs, we cannot decide.
No, Lordship, then what I would request my Lordship is to call for the affidavits, Lordship, how the dredging has been done, Lordship, and how much loss of life and livelihood has been done, Lordship, because we are not against dredging. Dredging is absolutely necessity, Lordship, but the dredging has to be done in a proper way, Lordship. This is what
we will direct the appropriate authority to constitute a team of experts so that they oversee the operations in a proper manner. That's the maximum we can do.
Yes, Lordship.
And we cannot monitor this, that, etc.
No, I'm not seeking the monitor, Lordship. We are not against dredging, Lordship. We are for dredging, Lordship, but the dredging has to be done in a proper way, Lordship.
Yes.
This is all what.
And what is the expertise of the writ petitioner?
Lordship, the petitioner is a local person, Lordship. He knows the starting point, the ending point.
That is correct, sir. He knows the topography.
He
what is his expertise in this sort of scientific dredging which you are saying? What is his expertise?
Scientific dredging.
How, if he doesn't have personal knowledge, how does he allege that what is being done is unscientific? Unless he says these are the standards, this is how it has to be done.
Lordship, because Lordship, he has seen, Lordship, how a dredging has been done, Lordship.
That's all. See, in view of a person sees that and he says it's unscientific. Unless he has got some inputs, he has got a report, or he himself is qualified, then he can brand the other person's activity as unscientific. If he doesn't have any first-hand knowledge,
fact is, Lordship, so much of loss of
life and I think then probably
Lordship,
there is some allegation or some grievance against the 11th responder.
No,
Dynamic. That is the company which is doing this operation, and he has got some.
Dynamic was being pressed into service for the survey, Lordship, for the survey part. Now,
please come. Please take
the dredging has been done by
this
DD, Lordship.
Filed as a public interest litigation, the petitioners would allege that the dredging of the various canals in the falling within the East Kolkata Wetland Management Authority are being carried on in a most unscientific manner, creating loss of livelihood of the people in the locality and also flora and fauna. Though the petitioner alleges that the authorities are adopting an unscientific method, there is nothing placed on record by the petitioners to state as to what is the manner in which the dredging is termed as unscientific. The court cannot take a decision based on photographs. The learned advocate points out to a photograph in page number 30. Not 30, sorry. Where he showed that 31. A photograph showing a dredger which is stationed in a water body. However, the other photographs show that in the canal there is no sufficient water. And if that be the case, a dredger cannot be placed in those canals, and necessarily excavators have to be used by placing the excavators in the banks. In any event, if dredging operations have to be done, it should be carried on in a scientific manner, and we are confident that the seventh respondent, namely the East Kolkata Wetland Management Authority, will have the sufficient expertise to ensure that the dredging is carried on in a scientific manner. If the seventh respondent is of the opinion expert advice is required in the matter, the seventh respondent shall do so by calling the experts in the field and seeking their advice as to how best the dredging operations can be carried on without damage to the property and also to the livelihood. With the above observation.
My lord, that defiltration has already been done. I have submitted the photographs.
The learned government advocate submitted that the dredging operations have been carried out in at least in 2 areas.
My lord.
In 2 of the canals.
Two of the rivers.
Two of the canals, and photographs have been shown. This the said submission is placed on record with the above observation. Question disposed of. Next.
I don't know, 53.
In 53, my lord, I am appearing for the petitioner, my lord. Lord, in the last occasion, my lord, your lordship had passed a very succinct order taking care of the entire grievances. There are 2 plots, my lord. One is they are saying that tea garden is acquired from scheduled tribes, and other one they have said they have taken direct lease from the state, 21 acres and rest. My lord. The report which your lordship called for, my lord, the report is there.
Seventh respondent has to file a report.
Report, we have got an advance copy from the advocate on record of the state.
Where is the report, sir?
Yes, sir. Oh, you got it already. Now, my lord, with respect to that report, my lord, my case is vindicated partially. In the sense, my lord, that if your lordship kindly take the report, my lord.
Yes.
The report, the second page, my lord. This is in report in connection with the order passed by the Honorable High Court at Calcutta, such and such. Now, my lord, kindly, my lord, take the 3rd paragraph. As far as the transfer of ST land to non-STs are concerned, necessary prior permission.
We don't have that report.
My lord, your lordship, my lord, kindly take the report. My lord,
report of the
my lord, this report was submitted pursuant to your lordship's last order by the respondent number 10 and 11. Look, these are the state authorities.
Yes, 10 and 11 report is there.
10 and 11.
There are 3 that says allegation in this public interest litigation.
No, my lord, we have been supplied with this copy of the report.
Oh, not the affidavit, report.
Report, yes, my lord, report. I'm sorry, my lord, I should have understood it, but I'm extremely sorry. The report, my lord, in connection, the third page, my lord, the third page. This is the material portion of the report. Will report in connection with the order, my lord. Oh, my lord, this is, I have just now received it from my learned friend. My lord, this is a different report. My lord, we have been supplied through WhatsApp
an advance copy of the report, which has been signed by the additional district magistrate, Alipurduar. To Mr. Siddiqui, my learned friend on the government side, Nilutpal Chatterjee, my learned junior friend on the government side, and Amrit Lal Chatterjee, all government advocates. They have also given copies to them. And Mr. Chatterjee has forwarded, in his usual fairness, a copy to us, so that we are prepared before the court. That is.
We don't have.
But the report which has been just now handed over to your lordship is quite different. I have got a copy from my learned friend just now, my lord. But anyway, Lord, any rate.
All right. What does that report say?
This report says, may I be permitted to produce that? I've just got a copy, my lord. Justice Bhattacharya will kindly forgive me. This report, if your lordship kindly takes the third page, my lord. The third page. Paragraph 3 is the material portion, my lord. May I indicate? As far as the transfer of ST land to non-STs are concerned, necessary prior permission has to be sought from the revenue officer. As per section 14C of the 1955 Act, this is the land. As per the said Act, PO come DWO BCW, this is the backward class officer who is entitled specially empowered to look after the ST matters, has been empowered to act as revenue officer for such matters. Hence, the necessary report regarding the said transfer may be obtained from the office of the PO come DWO BCW. Now, my lord, kindly turn, my lord, to the next page, well, the next material page, which is, my lord, since it is not paginated, my lord, it is the fourth page from the last. Fourth page from the last. Lord, just before this chart system.
Yes.
Lord, this is the report which the project officer come DWO, that is the backward class officer, my lord, gives, he writes, my lord. Now he passes the buck, maybe rightly so, to the additional district sub-registrar Alipurduar. My lord, he says, in view of the, kindly, my lord, take second paragraph of that letter. In view of the same, you are requested to kindly ascertain the status of transfer of the alleged tribal land, whether it has been done under the provisions of WBLR Act 1955, that is 14C, and send a report to this end along with the supporting document, if any, in support of their claim. So, my lord, my submission today is that, my lord, since the sub-register has, because that is the place where these transfers have taken place, that is the main den. So, my lord, let the sub-registrar be directed to come out. If they have 14C, I'm out of court. And if they don't have 14C, my lord, my case is vindicated. It is as simple as that.
All right, let him file a report.
Your lordship, I'm being led by Mr. Siddiqui. He's on like before another division.
He will direct in terms of this project officer's request to this additional district sub-registrar.
Yes.
Let him file a response and whatever is it, communicated to the project officer and you produce a copy.
My lord.
Yes. We have heard the learned. Written instructions have been given to the learned state advocate by the additional district magistrate within bracket general Alipurduar dated 13/5/2023. In the annexures to the said communication, we find that the project officer come district welfare officer, backward classes welfare and tribal development, Alipurduar, by memo dated 4/5/2023, has addressed the additional district sub-registrar Alipurduar, calling for a report as to whether the transfer of the alleged tribal land had been done under the provisions of the WBLR Act 1955 and also called for supporting documents, if any, in support of their claim. It appears that such a report is yet to be received from the additional district sub-registrar Alipurduar. Therefore, we direct the additional district sub-registrar Alipurduar to respond to the communication received, respond to the memo dated 4/5/2023 of the project officer come district welfare officer and submit appropriate reply along with supporting documents within a period of 15 days from date. Let the copy of the said response of the additional district sub-registrar Alipurduar be placed before this court on the next hearing date. Give a date after 20 days.
I'm deeply.
Item number 54.
Lordship, I on behalf of,
You are for the petitioner.
yes, Lordship, I on behalf of petitioner praying for not today, Lordship. Item number 54.
All right, the learned advocate for the petitioner seeks for adjournment. Give a date after 3 weeks.
Item number 55.
Lordship, item number 55, Mr. Srijit Chakraborty has been appearing in this matter. I am praying for not today.
He appeared. Why not today?
I'm appearing with the respondent numbers.
I'm appearing for the Kolkata Municipal Corporation. We are filing our report.
You have removed all the unauthorized.
Yes, it's in the report with pictures.
Archaeological survey. Inspection করেছে report করছে না। Inspection করে নিয়েছে। দেখেছি কিছু রিপোর্টে আছে যে ফোন করেছিলাম সরকারি অফিসার।
Now, work, according to your report, work is in progress.
Lordships, I beg to appear on behalf of the Archaeological Survey of India. We have carried out the joint inspection of the property along with the KMC, my lord. We are praying for an accommodation. We will file the report.
All right. In terms of the directions issued by this court on 25/4/2023, steps have been taken by the Kolkata Municipal Corporation, and the same has been set out in the in the form of a same has been set out in the affidavit filed by the Kolkata Municipal Corporation dated 14th June 2023. The said affidavit is taken on record.
Many copies.
From the said affidavit, it is seen that the work, the directions issued by this court on 25/4/2023 is in the process of being implemented. They let the Kolkata Municipal Corporation file a report after the work is fully completed, duly supported with photographs. The learned advocate appearing for the Archaeological Survey of India submitted that in terms of the directions, joint inspection was conducted and prays for time to file a report. Let such report be filed on the next hearing date.
Grateful, my lord.
Copies of this
I've
report
handed
served
over
on the
copies.
learned advocate for the writ petitioner.
I've handed over copies also.
Next.
Grateful. Now 56.
For 56, my lord, I appear on behalf of the added respondents. But there is one difficulty, my lord. My junior in the matter, Mr. Suryanil Das, he was there, my lord. He had to leave the court suddenly today, my lord, owing to some personal difficulty.
Right, also the matter was mentioned 3 times before lordship, because there is some urgency in the matter. From 4th February 2022, the election was not held in respect of the bank, which is a great financial institution. Entire board of directors was not constituted. By taking that time, they are not doing this election, nothing else. There are 3 orders of this honorable court directing the election commission to hold the election. But in spite of that, election program has not been initiated but not concluded.
I was humbly beseeching your lordship, my lord, if it can be taken up tomorrow, my lord, because my lord, there are proceedings pending before the election commission also.
But I could not understand why the election will not be held in respect of a bank.
No, first of all, my lord, we were not added parties, my lord. One after another, my lord. it
On
is
the earlier
nothing but, my
occasion,
lord,
he paid for time on several occasions. That's why
no,
the
no, my
matter
lord,
could not
there
be
was
done.
no petition, no copy served upon us, my lord. There
Yes,
was a
the
formal
copy has to be served
application
upon
was made thereafter. We were implemented as party respondents.
No, only you also kindly give a direction to the cooperative election commission to hold the election. There
But
are
the
three orders
issues
of
are
this already
pending, my
gone.
lord, before the
All
cooperative
these
election
orders.
commission. The records are not with me today, my lord. My lord, kindly takes it up tomorrow, my lord.
Who is he?
I'll
I
be in a.
the question of who is
But I understand, my lord, he cannot
He is
raise
not the
the
election
question, my lord.
commission.
Now that I have
He
been
has
treated as a
directed
party
election dispute.
respondent, this question, my lord, will not be germane as regards who I am, my lord, because, my lord, my intervention application has been allowed and I have been included as a party respondent. And against that, my learned friend has not gone up, my lord,
Kindly see the order of
under
the
Article
Honorable Court.
136.
Kindly see, there are three orders of the Honorable Court directing the cooperative election commission to hold the election. Election program was initiated. For 1.5 years, the election was not been held. Totally, the bank had been collapsed. No loan has been released. No recruitment has been done. Nothing of the sort. They're trying to destroy the bank.
And who has to conduct the election?
My lord?
Who has to conduct the election?
Lord, I appear for the cooperative election commission, lordship. My lord,
Kindly see.
it's a matter, my lord, where 86,000 voters throughout West Bengal. Now, my lord, 14 constituencies in West Bengal. And my lord, out of this 86,000 voters, 109 my lord, delegates are to be elected. Now, my lord, these delegates are members from different corners are fighting, my lord, with each other. They're filing cases one after another. He is one of such litigant. We are facing 86,000 voters. Now, my lord, time to time, we are trying to get our voter list finalized. But the moment we proceed, then, my lord, from one corner, it is coming that some voters, these are missing or they have, my lord, they are died. So you want to have a clear, my lord, voter list, final voter list.
No, you give a time schedule.
Only, my lord,
First-
I tell you, lordship.
First,
only-
you have to finalize the voter list.
Yes.
Within what time you will be able to
My
finalize?
lord, we cannot. We are expecting, my lord, the voter list to be submitted from the different corners of the branches. Because they maintain their register with the election commission. We, my lord, at the time of election, we come into the picture. And, my lord, we take, my lord, steps to hold the election.
Only one thing, page 80, can see the election program.
Please.
Final voter list has already been published.
My lord, my dispute case
Thereafter-
has not yet been
thereafter the bank
disposed
is
of,
under
my lord.
the
It's
special
been kept
officer.
pending, my lord, by the
Sir,
state
and,
election
my lord,
commission.
one thing is this, whenever such election disputes will be coming up, then, my lord, election disputes will be filed before the election commission. We are, my lord, we are having such
Why the
election
commission will not
disputes.
hold this election? I am putting
But
question.
I am telling the difficulties. We have filed our affidavits.
Very difficult on several occasions, but you are not holding this election.
Sir, you give us the voter list.
Voter
We want
list.
final
But
voter
can you
list.
see the election program? I have annexed this, page 80.
But in my intervention application, my lord, I had indicated categorically, my lord, some instances of dead persons, my lord, being included, my lord, in the
All
voter
right,
list.
sir. Yeah. Someday at some point of time, election need to be conducted.
Yes.
If dead persons are there, who is the authority who will finalize the
My
voter
lord,
list?
I tell you,
let them,
lordship,
my lord.
we are facing
No.
some election disputes.
My lord, let
Let
them,
those election disputes be disposed of at the earliest.
my lord,
We
that
shall
is
be on
exactly the
basis
direction
of
I was
that.
also praying for, my lord.
Page 78.
Because my
How
dispute,
long?
my dispute case is
78.
pending, my lord. They are not disposing it of, my lord, the state election,
On the
the
other occasion,
cooperative election
was
commission.
filed.
Lordship, we are
Commission has
facing,
passed an order
we are
that
holding
the
it.
election shall be conducted. Page 78, can you see? In an every occasion, one by one, election dispute will be pledged and the election will be postponed. Page 78, can you see?
These type of disputes are
But
coming,
their intention.
coming in several occasions
Yeah.
from the litigants.
But
One
they
or
are-
two litigants
but
coming,
they are
filing one writ petition.
destroy a financial institution.
And, my lord, that's why special officer has been appointed. He is trying to, my lord, summarize all these problems.
Election commission will come into play only after the voter list is.
Lordship.
Which is the authority who have to finalize the voter list?
Special officer of the bank, lordship. If there is no board of directors,
We will issue a direction to the registrar of cooperative societies.
he cannot do anything, my lord.
He can issue a circular to all the societies that within a particular time frame, they should finalize the
My
voter.
lord, special officer has already been appointed. He is on the job. So, my lord, special officer may kindly be, my lord, that is the government's decision. Special officer, my lord, will collect all these, my lord, voter list.
No, he is not a respondent here.
Yes,
should be. My lord, he must be.
Only one.
As per my
Ninth
lord,
respondent.
section.
Ninth
sec-
respondent.
Ninth respondent.
Ninth
Lordship.
respondent. Deputy registrar comes special officer.
No, he is not the special officer, lordship, perhaps. Special officer here I have said, my lord, in our affidavit of opposition, that we have said, my lord, who is the special officer here? My lord, we have said,
Page 139.
my lord, Jyoti Shankar Mondal,
Yes.
retired ARCS, my lord, he has been appointed as my lord special officer on 7th February 22.
And he is not a party here.
That's they have not made. It is we have filed our affidavit. They should have been made a party, because in absence of board of directors, special officer will do all the jobs of the board of directors. Why they have not implemented? These way, a lot of
Filing the writ
petitions
petition,
are coming one way. One.
they are acting change. Page 138. Kindly see page 138. Kindly see. This election program was
Let
published.
let him be added as party. Direction begin
no.
to special officer to give us the voter list
What time
and
to install
time
this
frame
process?
be done.
Your intention to install this process. Your intention. But
Election
kindly 138 page
voter
138.
list.
By virtue of the court's order, this election program was submitted before the honorable court, and on the basis of that, the direction was given to the Cooperative Election Commission to conduct the election. After that, the election has not been conducted.
My lord, he is not fully aware of this.
Wait, sir, wait, sir.
Lordship.
This program is already over. Page 138 program, time is already over.
Look.
This was issued on 30th April.
2022.
This is the 30th April 2022.
Well,
This is already over. This schedule is lost. Now this Jyoti Sarkar Mondal, who is the Assistant Registrar of Cooperative Society, South 24, he has been appointed as a special officer. We will implead him.
He was appointed, Lord. He was last. For 6 months, I do not know what's the Lord latest position that state can apprise. He was appointed for 6 months, Lordship, that time. That was the dated on Lord.
Only page 139. Kindly see. Sri Shankar Kumar Pradhan has been appointed 28th October 2022 as a,
After 6 months of that.
yes. He is now special officer.
He is the special officer.
Yes, he is a.
So we
as
will
a-
implead him, let him appear. We will fix a time limit within which he has to finalize the voter list. 6 weeks, 3 weeks, 4 weeks, 8 weeks.
ওটাও তো expire করে গেছে তাহলে 6 months এর জন্য ছিল তো তাহলে
They can apprise. I
it was for 6 months. October for 6 months ends on April, my lord.
Only Lord
What
state.
can be done?
Only
For
the
6 months, one year will be appointed, no election will be conducted, his tenure will be expired, again year will be appointed. But this is the process to install the election process.
My lord,
And the commission has to tell this, page 139 is your communication.
Yes.
Page 139.
My lord, ideally, my lord, the commission should also come up, my lord, with the fate of our dispute case, my lord. It is not being disposed of.
That's why you lost, you can give a direction to the commission.
no.
Complete the
Election
election.
commission, we are ready and willing. We are duty bound. If my lord, time frame is there, we'll have to do. But we must have the voter list.
You please see page 139,
Yes,
139.
Lordship.
Please read that.
In connection to above, I am directed to inform you that Sri Sobuj Boron Sarkar, Assistant Registrar of Cooperative Societies, Calcutta Range, is hereby withdrawn from the election duty of Kontai Cooperative Election Bank Limited, entrusted upon him by memo number Sajan. Now, Sri Shankar Prasad Pradhan, Cooperative Development Officer, and Purulia Range is requested with the duty of the Assistant Returning Officer in the elections of the delegates, as well as BOD of Kontrai. That's the part we are in the process.
No, whether this person is still.
He's here. Here, that is our duty, my lord. Our duty. If one hero is not there, we shall appoint another hero. But we want voter list. That is to be provided by the special officer or the bank.
Now, the special officer's term is already over.
Only state can apprise that. My lord, register very well.
State, there's nobody today.
My lord, they must either tell the name to be added and it will be completed.
The secretary will appoint the assistant returning officer.
Who is the special officer as on date?
But
You take information, come.
ARO will be appointed.
ARO different issue. ARO election part.
So what election part is concerned, I want to
complicate the issue.
Now, as on date, whether this Jyoti Sarkar Mondal is the special officer or any other officer.
Still special officer.
Are
is
you
still
sure?
Yes.
the present writ petition seeks for a direction to conduct the election of the delegates and board of directors to the Kontai Cooperative Bank Limited. Earlier, a schedule was drawn on 30/4/2022, but the election schedule was not implemented for various reasons, and the time frame fixed in the election schedule has already expired. From the affidavit in opposition filed on behalf of the respondents 3 and 4, it is seen that Mr. Jyoti Sankar Hon'ble, Assistant Registrar, AR is assistant or additional? ARCS.
Lord, I have no instruction, Lordship. My petitioner is saying so, Lord. I am sorry, Lordship. That state can apprise. I have no instruction. I cannot say.
What is the ARCS means assistant?
Here, Assistant Registrar of Cooperative Society, Lordship. ARCS.
Assistant Registrar Cooperative Society, South 24 Parganas Range, has been appointed as a special officer by memo dated 7/2/2022, and he has taken charge on 7/2/2022. In the affidavit in opposition filed by the respondents 3 and 4, it is stated that there are several litigations and the special officer could not take steps for conduct of the election. In order to have a clear picture, we suo motu implead the special officer appointed by the state for suo motu implead the special officer for conduct of elections
So for providing, Lord, the final voter list, draft voter list
of the Kontai Cooperative Society, South 24 Parganas State, as the 12th respondent in the writ petition. The petitioner is directed to serve notice on the said special officer, so that the special officer shall file notice on so and so. And there will be a direction to the special officer to file a report as to what is the stage of preparation of the voter list for the purpose of conduct of election to the said cooperative society. Let notice be served within 7 days from date. Let the matter appear before this court. Let the matter appear after you give a date after 2 weeks.
Right, it will be Kontai Cooperative Bank, Purva Bindipur.
Kontai Cooperative Bank, Purva Bindipur.
And my lord, in terms of the last order, my lord, our implement application was allowed. Now, my lord, we were added as parties, my lord. Yes, but there was no formal direction for filing of affidavits, my lord. In the meantime, my lord, we can also come up with an affidavit.
11th respondent is, you can give the correct address of the special officer. In the meantime, liberty is granted to the 11th respondent to file affidavit in opposition.
Grateful to your lordship.
Extremely grateful, Lordship. We are waiting for the voter list, Lordship. Voter list, once we get, we'll have to. Item 57, grateful, Lordship.
57, my lord, I'm appealing for the petition.
I am for
My
the
lord.
CBI.
My lord, one of our chambermaids has lost his relative, my lord, his father's bigger brother. My lord, we have to leave for him. My lord, I was only praying the matter be taken up next week. So there's some personal difficulty. The whole chamber is to.
My lord, it may be kept on Tuesday.
Request of the learned advocate for the petitioner. Adjourned. Next.
58.
But it would appear on the next Tuesday.
58, my lord, I am seeking time, my lord, only because of I was late by learned advocate general in this matter.
Grateful, my lord.
Kindly, my lord.
My lord, I am for the petitioner. My lord, kindly seize my lord's order dated the last order, my lord. Because this is the case where 4 persons had unnatural death while in police custody in Baruipur Hospital.
That's why, my lord, I am seeking time, my lord, because late advocate general.
Yes, and my lord, I have no objection to that. However, my lord, I want to point out that today was a direction for the CID to submit a report.
No, that's why, my lord, so far the report and other parts is concerned, my lord, on the next day when he will be there, my lord, we will.
When do you want?
Next week, my lord.
Then, my lord, may I make one small prayer, my lord, in view of the importance of the matter, my lord, if your lordship kindly fixes the matter next week at top, my lord, or 2 p.m. as it suits your lordship.
Next Tuesday, higher on both. At the
Lordship,
request of
Grateful, my lord.
Learned Government.
Grateful, my lord. Item number 59.
59, my lord, I am for the petition.
Lordship, my senior Mr. Somojit Bhotto appears on behalf of the respondent number 224. He is not come today. I am praying for not today.
What happened, my lord, during the pendency of this writ petition, the chairman of the concerned municipality issued a notice of hearing, fixing date of hearing on 17th August 2023 at 4 p.m. So kindly adjourn the matter for a period of 2 weeks. In the meantime, if any order is passed.
No you are for the writ petitioner.
I am for the writ
No
petition.
point of keeping the matter alive, my lord. They cannot pursue the matter parallelly. It's before the grievance committee. My lord, it's a 2018 writ petition. It's a second round they are filing. My lord, 22 order was passed.
Let the district magistrate take a decision. By this writ petition, the petitioner seeks for a direction upon the respondents to make an inquiry by a competent authority to take appropriate steps for demolishing the unauthorized construction and remove the mobile tower. The learned advocate appearing for the petitioner submitted that the district magistrate has taken on file the complaint made by the petitioner and has fixed the date of hearing on 17/8/2023. In the light of the above, we direct the district magistrate, namely the fifth respondent, to hear all the parties, namely the writ petitioner and the private respondent, as also the eighth respondent company, which has put up the mobile tower. And after hearing the submissions of all concerned, let a speaking order be passed on merits and in accordance with law.
Grateful.
Next.
Notice of issued hearing by the concerned municipality.
Municipality or district magistrate?
Yes.
Municipality, issued by the municipality.
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 Thank you.
Item 60.
Grateful.
My petition kindly case 28. See, case 28. When unauthorized construction was made on the plots in question, I made a representation. The court division passed an order. Page 28, directing the panchayat to take a decision on the basis of the representation of petitioners. Now, Lord, on the basis of that order, now the panchayat passed an order. Admittedly, they have admitted the unauthorized construction has been done, but they have regularized the unauthorized construction by taking the fees. This is not permitted under the panchayat.
Because the report says
The report
constructed illegally without taking any approval. During the inspection, no obstruction has been caused to the water drainage. Residents are permanently with family without taking any approval from the Gram Panchayat. No, you are appearing for the Panchayat.
But no,
No, I am for the state, not for the Pradhan.
I am
Pradhan
for
is
the private. I am for the private respondents.
Yes.
This was moved in the form of a public interest litigation alleging blockage of water through non-Julie. Lordship will kindly look at the report submitted by my learned friend by the state advocate. That is absolutely baseless. That's a false allegation. And we have all.
I have submitted.
And what is.
There are two things to it.
Yes.
One is in the report of the Gram Panchayat, it says that no obstruction has been caused to the water drainage. But in the same report, they say that construction has been put up without approval.
My lord, why I tell your lordship. Lordship will get it, my lord, from the report itself. Kindly, my lord, come to page 3 at paragraph 7. This is most surprising. The petitioner number 1 and petitioner number 2, they were holding the mud house on that plot. They subsequently sold it out to another person. Then, my lord, we occupied it. We have already applied for sanction of the plan to the video. That is under. Lordship will kindly, my lord, for a minute, look at paragraph 7 at page 3.
Page?
Page 3, paragraph 7 of the report submitted by the learned state advocate.
Yes.
It is stated that from the documents it has been found that the petitioner Gaudhari Das, he is the petitioner number 1. Gaudhari Das was once illegal occupant of the same place. He and others took rupees 1,25,000 only from the descendant of some person and then sold it out. We subsequently got the possession of that land from the buyers. My lord, stayed there there was a mud house. We were staying there. Now we have applied for sanction of the plan to the BDO. That may be considered and that and
sanction.
All right, please.
Why
this writ petition is filed as a public interest litigation. Petitioner alleges that the private respondent has put up illegal construction over a water course. The inspection has been conducted and a report has been submitted on 1/12/2022 and an affidavit in the form of a report and a report in the form of an affidavit has also been filed by the block development officer and executive officer of Dantan 2 Panchayat Samiti. On going through the report, it is seen that the writ petitioner Gauri Haridas was once an illegal occupant of the same place and he and others took rupees 1,25,000 from the descendants of,
That I am denied by the exception. I have denied that.
And from the descendants of so and so. Page 3 of this. I will put this. So and so. And therefore it is submitted that the present writ petition is not a genuine public interest litigation. The learned advocate appearing for the writ petitioner would vehemently submit that the said allegation is absolutely false and exception to the said report has also been filed. In any event, the authorities having inspected have found that there is no blockage to the water channel, the water drainage of the drainage trench. Nayanjuli. Full stop. However, with regard to the nature of construction which has been put up by the private respondent, the authorities are at liberty to take action in accordance with law if there is any illegal construction without any planning permission. With the above observation, it should dismiss. Next.
But kindly give it time limit. Kindly give it. But admittedly, I'm not
Next.
And now 61.
I beg to appear on behalf of the petitioner. The allegation in the petition is that in South 24 Parganas, there is a notorious racket who is operating, distributing drugs and narcotics substances. He is a very influential person and there are being unnatural deaths because of this drug addiction amongst the youths in the locality which every month there is 1 or 2 deaths. So there was a detection on the last occasion upon the state authorities to submit a report so that we can take an exception because the state authorities
and the 8th and 9th respondent was served.
Yes, they are available. They have won the election. The last election they have won. They have purchased properties in the last few years worth several crores of rupees. Very recently,
criminal cases are pending.
Criminal cases are pending where police has submitted a report saying that they are absconding. Every day or the other, there is a dais in the locality where he is being felicitated and all these are going on. So, we are just waiting for the report from the state authorities so that we can take out an exception to that, annexing documents to our exception showing that he is available there.
But on the last hearing date, somebody appeared for the 9th respondent.
Correct.
Samim Ahmad.
Yes. Mr. Shamim Ahmed appeared on 13th of February, if I am not wrong.
And anybody for the state?
Oh, Mr. Ahmed is here.
No.
দাদা ওই বারুইপুরের কিছু একটা মামলা।
You have appeared.
Right.
He says your client is an accused, engaged in all narcotics dealing, freely roaming around, won the panchayat election also. But in this booth, you have not filed a writ petition. You should have filed writ petition, how your client managed booth capturing, how the ballot boxes were taken off. We will so moto issue notice where he won the election, which is that constituency.
With that minute, I need to
You
take
need to,
instruction.
we'll, in that election matter, we will, so that he can appear for the respondent for a change.
For a change.
So let us see which case he wins, whether for the petitioner or for the respondent.
If there is a conflict of interest, I cannot appear in
All right.
either of the matter.
Anybody for the state?
Ultimately, we'll be beseeching for an investigation by the Central Bureau of
Mr.
Investigation.
Amitesh Banerjee appeared for the state. No, you are not appearing, we know.
The report has not come yet, Millard. And Millard, ultimately, Millard, looking at the report, Millard, will
There is no report called for.
yes, Millard, subject to correction, of course, by your lordships, Millard, in the order passed
No,
on
it says,
13th
suppose
of
several cases are registered against the respondent 8
But
and
I
9.
may recall, Millet.
Under NDPS Act, they have been declared as absconder by the competent courts, but they are freely moving around and are attending functions. He has referred to the photographs which we enclose supplementary affidavit. But a further allegation of the petitioner, private respondent brought properties worth several crores.
Then Millard, next paragraph.
So if the fact, if it is a fact that he has won the election, he can't be an absconding accused.
He is not, Millard, he is being felicitated every other day, garlanded and
But so far, Millet, I can recall, Millet, respond 9, Millet, I was representing Millet. Millet, there is no pending case. I am. And so far, my knowledge goes, Millet, there is no pending case against Millet, respondent 9. So far, respondent 8 is concerned, there is so many cases, Millet, of narcotic Millet. And Millet, so respondent 9 is the Millet, it represented me. Who was not allowed to Millet to function Millet by the ruling dispensation Millet. That was my case, Millet, I can recall Millet. Respondent 8, there is so many cases pending. So far, respondent 9 is concerned, Millet, there is no case.
They are brothers and sisters.
Maybe.
Rahima Laska.
Yes, that is right, Millet. They're brother and sister, but so far 9 is concerned, no case, Millet. So far 8 is case.
Pintu Laskar.
Yes, against Pintu Laskar, Millet, there is so many cases pending.
His sister is Millard, respondent number 9.
Rashid Laskar. Who's Rashid Laskar?
Rahima Laskar, Millet. I am representing Rahima Laskar, not Pintu Laskar, Millet. আমাদের দিয়েছে প্রেসটা নিয়ে আসেনি কেউ মনে করায়নি দিয়েছে
মিস হয়েছে লিস্টে ভোটে জিতেছে কে রহিমা না
রহিমাই হবে পিন্টু না
রহিমা
দিয়ে গেছে কিনা সন্দেহ না স্যার মনে আছে
নাম্বারটা
I think it's a family business.
Doing very well.
Because everybody is this Laskar.
Yes. And my lord, very recently, if my lords, my lord, kindly permit us, my lord, we have been, my lord, handed over some photographs. My lord, this is, my lord, everyday scenario, my lord, everyday site, my lord, in the locality. If my lords kindly quickly just, my lord, turn over the pages.
And who is this person?
My lord, these are addicts. And my lord, multiple youths are, my lord, now chained, my lord, at their homes because of, my lord, this addiction. Every alternate house, my lord, there is one or two addicts. That is, my lord, my specific
But
instruction.
have you produced any material to show that the 8th respondent,
Yes, my lord.
this Pintu Laskar, is shown as an absconding accused?
My lord will kindly, my lord, take page 23 of my petition, my lord, the public interest litigation writ petition, page 23.
Yes.
Second paragraph.
This is a order passed by the
By my lord, the trial court, my lord, in criminal case, in one of the NDPS cases. And this is what police is saying. My lord, third line of the second paragraph, rather, my lord, the second line towards the right hand side, I find that this absconding charge sheet has been submitted against Sophie Klasker alias Pintu. Warrant of arrest has been issued.
Page?
Page, my lord, running page 23.
23.
Yes, my lord, second paragraph, if my lords kindly take the trouble to have a look at.
Heard the PP in charge?
Yes. It is evident that charge sheet has been submitted and cognizance has been taken. On perusal of the second record, said record passed on 2nd of March 2019, I find that the absconding charge sheet has been submitted against Shafiq Laskar alias Pintu. Warrant of arrest was issued way back on 12th of November 2018.
And the case is still pending?
Yes, my lord, that is my
NDPS
instruction.
85 of 80.
They do not mind.
We have heard the learned advocates for the parties. In terms of the order dated 13/2/2023, the state was required to file a report in the form of an affidavit within 2 weeks from the said. However, no report has been filed. We direct the appropriate authority of the state to file a report on the next hearing date, failing which exemplary cost will be imposed on the appropriate authority. There are certain serious allegations made against the 8th and 9th respondent. And it is submitted though the 8th respondent has recently
possibly 9th. My lord, I need to take instructions. My lord, 9th respondent who has won the recent Panchayat election.
But the 8th respondent?
8th, my lord, he was involved. My lord, he has possibly was not the candidate. 9th, my lord, has won the election. My lord, I need to take specific
serious
instructions.
allegations against the 8th and 9th respondent. And it is submitted that the 8th respondent is freely roaming around.
Yes.
And however, in the criminal cases which have been registered against him under the provisions of the Psychotic and Narcotic Substances Act, he has been shown as an absconding accused. In this regard, the learned advocate for the petitioner has referred to the order passed by the Court of Additional District and Session Judge, 4th Court, Alipur, South 24 Parganas, in NDPS-85/18 dated 27/3/19. From the said order, it could be seen that absconding charge sheet has been submitted against the 8th respondent. There will be a direction to the respondents 4 to 7 to ensure that the 8th respondent is arrested and produced before the additional so-and-so court in connection with NDP so-and-so court in connection with the not in connection in NDPS 85/2018, and after producing him before the said court, the appropriate police authority shall file a report before this court. In order to ensure that the above direction is complied with, the third respondent is directed to monitor the entire matter. Let the state file a report in terms of the order dated 13/2/2023. List on so and so date.
Grateful, not extremely grateful to your lordships.
Before your lord, kindly pardons me, my lord. And I was renewing my prayer for item number 97 to be taken up out of turn, my lord. I shall serve, a person, despite your lordship's court's order, my lord.
We will take it up. We have come up to 60.
No, but after recess is original.
Original say. Today we can't take.
So please wait. Next week, it will be taken up from 62.
Yes.
Because today your lordship has reached 61. I am in 62.
What is your?
What can be done? Because it is now, time is over. I cannot detain your lordship any further. So from 10:30 to 1:30, it's more than. I cannot detain.
When it will come?
Next Monday.
Next Monday.
Next Monday,
Next
most
Monday,
humbly pray that
may it be taken up from this adjourned bill.
Yes.
May-
From this.
may-
Matters can be taken up. It is start from 62 only.
But your lordship kindly make it from 62 onwards, because otherwise
No,
bottom
don't.
will not get any chance.
Matters, you put it below. This is not reaching it. That will not be broken.
No.
Something on top may be added.
Not that. Because the adjourned bill, which is adjourned today, has not been taken up. That will again come up.
No, these are fixed.
ये বলছি কেন?
After new matter, this
Yes,
is
we will try to do something.
Milord, item number 60.
Instead of Monday, may I most humbly pray, a person illegally is functioning, day after tomorrow, if it can be listed.
Everything is illegal, sir. That is
Milord,
why so
if it
many
can be
cases-
listed, on Wednesday, as a special case,
No, Monday you are not available.
No, I am. But as a special case, because a person is,
It will reach. Let us think positive.
Yes.
as your lordship.
Returnable data.
Original side daily list item number 1.
Well, I am for the respondent SCC, my lord. Well, in this
Right,
matter,
last occasion, my lord had allowed my learned friends recalling application.
Pardon?
It was my lord, my learned friends recalling application.
Yes.
The last occasion, my lord had allowed that.
my lord, there is a delay of 1165 days delay. My lord has passed in case judgment on 31st October 2022 in case of Vasudha Jain is squarely covered, my lord. May I hand over the copy of the judgment? To একটা correction করা আছে।
So you made pencil mark.
I have fresh copy also may hand it over, my lord. One copy.
I may not really, my lord, stand anything to differ with this view, but my lord, only my point of my lord, opposition, that was my lord, I tried to convey to your lordship in the last occasion that the ground taken by learned friend with regard to my lord recalling this, one of being such that despite his appearance, he said, my lord, that he was not appeared on that day, my lord. But still, my lord, since that was over, so I do not embarrass your lordship to indicate that again. But with regard to my lord, the precedent which my lord is showing, there is nothing else as such, my lord, to differ.
Already we'll follow this. Actually, judgment. They changed the prostate. Pencil, please see. Number, etc. Appearance also they have changed. Number of days delay, date of order. Here, from the state edition, page 7, para 7, page 4. That will be the questions. Instead of this, you have to substitute from here. Other things they have written here, ITA numbers, etc. Same order. You can download it.
Yes.
Thank you.
For admission item
Report on
number
before
2.
us.
I appear for the assessment.
Yes.
This is my appeal, my lord. My lord, the short point here is, my lord, there was a limited scrutiny. Thereafter, scope was enlarged. But before the order was passed, show cause notice was given, and after hearing the party, SSC, the order was passed. The verification report was also given. Against that, the commissioner passed a judgment that passed an order saying that this cannot be done based on 2 circulars, my lord. This which was also upheld by the tribunal, my lord. Now, my lord, will kindly come to page 15. That's the assessment order, my lord. Lord, I'll just place the first paragraph and then SSC firm file its return of income electronically. Bearing acknowledged numbers so and so for the assessment year under consideration, disclosing total income of 2,18,000. Case was selected for scrutiny through CAS under the category of limited scrutiny. And notices under section 143 subclause 2, 28/7/2016 and 142(1) were issued and duly served upon the SSC in time through given email address and also by speed post. In response, Surendra Kumar Savaria of the SSC firm appeared from time to time, produced requisite document. My lord, I will skip that part and then Lord will kindly come to page 16, last towards the lower middle, initially. Initially, the case was selected through CAS under term as limited. The reasons were as under: interest expenses, income from real estate expenses, sales turnover mismatch, for other expenses claimed in the profit and loss account. The reasons was duly intimated to the assessee firm through notice under section 143(2). Later on, at the scrutiny assessment stage, considering the gravity of the case as it is revealed and information received from other wing of the department, case was converted into a complete scrutiny after taking necessary approval of the competent authority, and the same fact was duly intimated to the assessee firm. Thereafter, my lord, the assessment was done on this basis. After hearing the other side. Now, my lord, will kindly see the CITA.
Now, while page 16,
my lord,
was a fresh notice issued for this complete scrutiny?
Initially, it was not issued. Initially, it was only limited scrutiny.
Yeah, correct.
Thereafter, 10 days before passing the order.
So it says converted into complete scrutiny.
Yes.
After taking necessary approval.
Approval was taken.
But then did you issue a fresh notice?
There was fresh notice was issued, my lord. Fresh notice was issued, but before the hearing, he was heard. But in this case, the investigation part was done earlier. Before the notice was issued, my lord. The complete scrutiny investigation was done earlier, before the notice was given. That is what was held by the tribunal as well as the CIT appeals. I will straight away go to the tribunals, which is at page 65, my lord. My lord, will kindly come straight away to page 67.
One second. But Commissioner Appeals did not examine this aspect, is it?
Commissioner Appeal did examine this aspect, my lord.
No, apart
Not
from,
in detail.
But apart from that, he went into facts.
He went into facts. Lord, that will be available from paragraph 5 at page 67, my lord. My lord, may see paragraph 4 and paragraph 5 of the tribunal that will make the facts clear.
No, CIT Appeals in page 50 at paragraph 5 says that page 50,
my lord,
paragraph 5, as regards second line, as regards the scrutiny alleged to have been conducted beyond the scope of the limited scrutiny, I do see that the AO issued requisition notice as if he was proceeding of a complete scrutiny, even though it was a limited scrutiny.
Correct.
Consequent to an information, the report so and so, so and so.
My lord, this is reflected in the paragraph 5 of the IT-80 order.
Hmm. So CITA did not give a specific finding
Yes,
as
yes.
regards the validity of
My
the
lord,
complete scrutiny.
my lord. Which is why they filed an
That is
appeal.
why they filed a cross objection
Yes, yes, my lord.
or a cross appeal. But the inquiry was, tribunal says, the AR submitted, the AO converted the limited scrutiny to broad scrutiny only on 14/12/17, whereas the inquiry was made where the loans much prior to the date,
That's
thereby
correct.
rendering the assessment.
That is the only reason why this was found to be illegitimate.
And some instruction of the CBDT
My lord,
taking the bench.
my lord, if my lord sees the page 73 once, the circular. My lord, this circular starts from page 72. It is in the order.
This is that Dave Milk Foods.
Yes, my lord, in the order itself, the circular is there. My lord will kindly come to page 73 once and see paragraph 4 of the circular. May place that paragraph only, my lord. The board further desires that in all cases under scrutiny, where the assessing officer proposes to make additions or disallowances, assessee would be given a fair opportunity to explain his position on the proposed additions and disallowances in accordance with the principle of natural justice. In this regard, the assessing officer shall issue an appropriate show cause notice duly indicating the reasons for the proposed addition, disallowances, along with the necessary evidence and reasons forming the basis of the same. Before passing the final order against the proposed addition or disallowance, due consideration shall be given to the submissions made by the assessee in response to the show cause notice. My humble submission is that this has been done. Although the finding is that the inquiry was done earlier, but notice was given, he was heard, and on that basis order was passed. So substantive compliance has been made, my lord. This is my humble submission. No prejudice has been caused. One has to see whether there is violation of any natural justice at all or any prejudice that has been caused. And my lord also knows that procedural defects cannot vitiate the proceedings, my lord. And which is why I will place a few judgments on this, my lord.
But after they converted into a complete scrutiny,
yes,
probably the assessee was heard.
Yes.
But whatever was the inquiry which was done was much prior to 2017, those transactions.
No, my
Then
lord.
it gives a fresh cause of action.
Investigation was done while these proceedings were going on, but investigation was done while the limited scrutiny was on.
But then assuming that material was available,
yes,
at the earlier point of time, you chose to have a limited scrutiny, then it presupposes that the authority did not think fit to examine these aspects. That is why it says in this circular, scope of inquiry, specific issue-based inquiry is to be conducted only in those scrutiny cases which have been selected on parameters so and so. In such cases, the assessing officer shall also confine the questionnaire only to the specific issues pertaining to the data. Wider scrutiny in these cases can only be conducted as per the guidelines and procedure stated in Instruction 7 of 2014.
My lord will see this is with regard to specifically with regard to 2014. This is specifically for 2014.
First part. First part.
The first part is 2014. The second part, my lord, is 2015. The second part starts from paragraph 3, which is at page 73 for 2015.
Now, paragraph 4,
My lord.
you have to read this in conjunction with the other paragraphs. Once it is, the commissioner concludes that there is material for complete scrutiny, then the assessee should be put on notice. Here, this material was very much available when you issued the limited scrutiny notice. So is it not an afterthought? That's what they've milk, whatever.
My lord, on this material, hearing was given to him. It is not that any prejudice has been caused to him.
Definitely. Because limited scrutiny, CBDT also says it shall be confined only to the questioner.
My lord.
Midway, suddenly you wake up and say if there is fresh material, assuming during the limited scrutiny something crops up. That's a different matter. But CITA as well as the tribunal records that these are all material which were available prior to 2017.
Material was available, my lord. Material will.
That's what.
But inquiry and investigation could only be done once while doing the scrutiny, my lord.
But in any event, the commission appeals have gone into facts, and wherever relief can be granted, he is granted, and wherever it can't be granted, he has denied.
But ITAT has not gone into the facts at all.
No.
ITAT has relied on this. My lord,
They
then
are not an appeal against that portion.
my lord, then remands and said
not required. Yes, sir. What do you say?
We'll kindly take the ITAT order. The 3 dates are very important. One is July 26, 2016. That is when the limited scrutiny proceedings were initiated.
July
26, 2016. Then, my lord, February 20th, 2017. When, my lord, they expanded the scope of the inquiry. And on 14th December 2017, my lord, when it was converted into a complete scrutiny, the approval was obtained only on 14th December 2017. Prior to that, my lord, the inquiry was already undertaken, expanding the scope of the scrutiny proceedings. My lord, one important paragraph from the instruction, if the lordship kindly takes, page 70 for once. The lordship will find, may I just read out a little bit from paragraph 8, page 69 onwards. After hearing the rival contentions and perusing the material on record, and also notice dated 143-2 dated 28 July 2016 issued for limited scrutiny, covering 4 issues: interest expenses, income from real estate business, sales turnover mismatch, and other expenses claimed in the profit and loss account, and also subsequent issue notice issued under section 142(1) 20th dated 20th February 2017 called for information on secured and unsecured loan deposits. We find that there is no dispute that even prior to conversion of limited scrutiny to complete scrutiny on 14 December 2017, the AO has started inquiries during the year, even prior to that date, which is evident from the notice dated 20th February 2017, wherein the information details were called for secured and unsecured loans. This is not in dispute that though the limited scrutiny was converted into complete scrutiny on 14 December 2017, an order was passed on 20th December 2017, whereas the issue in respect of secured and unsecured loans were inquired and examined by the AO much prior to that date. In our view, this is in complete disregard of the instruction number 5 of 2016 issued by CBDT on 14 July 2016, which provides that while proposing to take up complete scrutiny, which was fixed for limited scrutiny, the AO shall form a reasonable view that there is a possibility of underassessment of income if the case is not examined under complete scrutiny, and that plea has to be on existence of the credible material, not merely on suspicion and conjecture of unreliable sources. We note that the instruction provides that there has to be a direct nexus between the available material and formation of such view. The relevant part of the instruction are reproduced here under. This is the relevant instruction. This is instruction number 5 of 2016. Kindly take, my lord, paragraph 4 of the instruction, which is at the bottom of page 70. It is further clarified that in cases under limited scrutiny, the scrutiny assessment proceedings would initially be confined only to issues under limited scrutiny, and questionnaires, inquiry and investigation, etc. would be restricted to such issues. Only upon conversion of case to complete scrutiny, after following the procedure outlined above, the AO may examine the additional issues besides the issues involved in the limited scrutiny. The AO shall also expeditiously intimate the taxpayer concerned regarding conducting complete scrutiny in such cases. Instruction number 4 provides only complete scrutiny after following the procedure laid down above, and the AO may examine the additional issues besides the issue involved in limited scrutiny, and the AO shall also expeditiously conduct complete scrutiny in such cases. We note that in the present case, there has been a complete violation of the circular issued by CBDT. The case of the assessee finds support from the decision of coordinate bench of Delhi in their products. Now, my lord, kindly take paragraph 6.0 of that judgment rendered by the tribunal has been quoted. Your lordship will find first the instruction number 5 of 2016 is quoted, though paragraph 4 is missing. After 3, there is paragraph 4 is missing. Now, my lord, what Mr. Kundolia referred to, that is the earlier preceding instruction, page 72. That is the earlier preceding.
That is 20 of 15.
20 of 15.
20 of 15.
So now this is governed by instruction number 5 of 2016, which precludes the assessing officer to conduct any inquiry beyond the limited scrutiny notice and prior to obtaining approval from the competent authority.
Here order was passed
on 14 December 2017.
No, it says 20th December.
20th December, not 14 December. On 14th, correct?
No. 14 was converted into complete scrutiny on 14
December.
Converted
and
into
an order was passed on 2012.
Converted to complete scrutiny.
And the order was passed on December 28. Now that's a typo. That's a typo.
December 28.
Subject to correction,
yes.
December 28. So,
two weeks after that.
He could not have expanded the scope even prior
to that. But that's a jurisdictional error. That's a jurisdictional error. That is not procedural error. And this is the earlier instruction.
My humble submission would be it's not a jurisdictional error. Because his jurisdiction starts after this letter has gone. Yes, but before that, at best, he may have made inquiries for which he has given ample opportunities to the other side to appropriately deal with.
Please come.
And my humble submission, I would rely on a couple of judgments, my lord.
Please. No, please. He wants really.
Okay. Judgment.
Okay. 1997 9 SCC 128 Venkata Sramappa are the
আরেকটা আরো একটা আছে
আরো একটা উত্তর পড়ে দিবি
এটা দিয়ে দিচ্ছি
97.9
my lord 97.9 SCC page 128 my lord I will refer this is not related to tax but paragraph 5 and 6 I would want to rely on my lord may I place paragraph 5
97.9
It is true that normally publication in the newspapers would be preceded by a publication in the Gazette notification. It would appear that in this case, while sending the notification, which was approved by the government for publication in the Gazette, simultaneously direction was issued to have it published in the Gazette. Therefore, it would appear that before publication in the Gazette was made, it was published in one of the newspapers. This is only an irregularity in the procedural steps required to be taken under this act. Under the act, it does not vitiate the validity of the notification published in the Gazette on 3rd February 1989. In support of the contention that it is mandatory that the procedure prescribed under section 4 subclause 1 should be strictly complied with, the learned counsel has placed strong reliance on the ratio of this court in the collective Allahabad versus Rajaram Jaiswal. There is no dispute on the proposition that publication of the notification under section 4 subclause 1 in the Gazette is a mandatory requirement. In fact, in that case, that was not done. The contention raised in Jaiswal case was that it is only an intention and not mandatory. This court has rightly rejected that contention. As noted earlier, since the publication of notification under section 4 subclause 1 was made on 23 February 1989, the intention of government was to acquire the land for public purpose as mandated under subsection 1 of section 4 of the Act. What transpires, therefore, is that the notification was made in one of the newspapers published earlier to the actual publication in the Gazette. As stated earlier, it was only an irregularity in the procedural steps to be taken under the Act. It is to be seen that the object of the publication of section 4 subclause 1 is to put a notice to the owner that the land is proposed to be acquired for a public purpose and that they are prevented to deal with the lands in any manner detrimental to the public purpose. Obviously, therefore, the publication in the newspaper would put the owners on notice of the proposed acquisition even prior to the actual publication. Admittedly, in one of the newspapers, notification was unauthorizedly published before the publication in the Gazette, namely on 1st February 89. The substance was also published as indicated in the proceedings of the land acquisition officer conducted on section 5A. The last of the dates was taken for the purpose of notification under section 4 subclause 1. In that view, we hold that there was no infraction of the compliance of the requirement under section 4 of the Act. So, my lord, what these paragraphs say is that if material irregularity would not take away the substantial law. This is one. এটা সরিয়ে দে। এটা ওখানে রেখে দাও। এটা আমার। I would also refer to Commissioner of Wealth Tax Meerath versus Sharwan Kumar Swaroop, 1994, Volume 6, Supreme Court Cases, page 623. And the checks. Now I refer to paragraph 10. Oh, bro. May I refer to paragraph? I rely on paragraph 10 to 14 and 18. May I place this?
Yes.
The basis of distinction between statutes affecting rights and those affecting merely procedure is well recognized. Dixon CJ in Maxwell versus Murphy, drawing upon the following words of Lord Justice Mellish in Republic of Costa Rica versus Erianga, said, "No suitor has any vested interest in the course of procedure, nor any right to complain if during the litigation the procedure is changed, provided, of course, that no injustice is done." It is true that if one traces any substantive right back far enough, it will be found secreted in the interstices of procedure. In W.H. Copperline and Company versus IRC, Lord Hansford quoted with approval a following passage from the judgment of Sergeant L.J. The liability is imposed by the charging section, namely section 38, the words of which are clear. The subsequent provisions as to assessment and so on are machinery only. They enable the liability to be quantified and when quantified to be enforced against the subject. But the liability is definitely and finally created by the charging section and all the materials for ascertaining it are available immediately. In Halsbury's Laws of England, referring to machinery provisions, it is stated, it is important to distinguish between charging provisions, which impose the charge to tax, and machinery provisions, which provide the machinery for the quantification of the charge, and the levying and collection of the tax in respect of the charge so imposed. Machinery provisions do not impose a charge or extend or restrict a charge elsewhere clearly imposed. The distinction between substantive law and procedural provisions has been indicated in Black's Law Dictionary as follows. As a general rule, laws which fix duties, establish rights and responsibilities among and for persons, natural or otherwise, are substantive laws in character, while those which merely prescribe the manner in which such rights and responsibilities may be exercised and enforced in a court are procedural laws. In Salmon's jurisprudence, the distinction between substantive law and law of procedure is indicated in the following word. What then is the true nature of the distinction? The law of procedure may be defined as that branch of law which governs the process of litigation. It is the law of action. Use quod ad action as pertinent, using the term action in a wide sense to include all legal proceedings, civil or criminal. All the residue is substantive law and relates not to the process of litigation, but to its purpose and subject matter. Substantive law is concerned with the ends which the administration of justice seeks. Procedural law deals with the means and instruments by which those ends are to be attained. The latter regulates the conduct and relations of court and litigants in respect of the litigation itself. The former determines the conduct and relation in respect of the matters litigated. What facts constitute a wrong is determined by the substantive law. What facts constitute proof of a wrong is a question of procedure. So far as the administration of justice is concerned with the application of remedies to violated rights, we may say that the substantive law defines the remedy and the right, while the law of procedure defines the modes and conditions of the application of the one to the other. Lord, will kindly see paragraph 18 then. The procedural law, generally speaking, is applicable to pending cases. No suitor can be said to have a vested right in procedure. It must, however, be noted that a provision can be partly substantive and partly procedural. So my humble submission, my lord, is that in this case, even if there was a procedural infraction or irregularity, which was later on, it has been duly, they have been given opportunities. No kind of prejudice has been caused to them. In such a situation, giving precedence to procedural law over substantive law will be a travesty of justice. No, huh? But if you see the scheme of 143, my lord, this aspect will not help because it is not whether it is a substantive law or a procedural. Under 143(1), once you file a return which has been made under 139 or in response to a notice under 142(1), return shall be processed under any one of the clauses. Then an intimation is being sent. If there is going to be a sort of adjustment of tax,
but no tax or interest is payable or no refund is due. The first proviso contemplates intimation be given. And there is also a time limit for that. No such intimation can be given after an expiry period of 9 months in terms of the second proviso. Then comes subsection 2. Where a return has been furnished under 139, response under 142.2, the assessing officer prescribed as the case may be considers necessary or expedient to ensure that the assessee has not understated the income or has not computed excessive loss or has not paid so and so, shall serve a notice requiring it.
Which has been done.
He can do it. So at this stage, so this cannot be said. It is a complete code. So here intimation was not given. Under 143.2, the assessing officer felt that certain aspects have to be incurred. So he places a proposal before his commissioner or whoever is the approving authority, saying that these 3 aspects I need to inquire. Approval granted. Therefore, the notice under 143.2 was confined only to 3 aspects. And that was inquired into. And in that process, what he said was, in respect of 2 other issues also, he commenced inquiry.
And my lord, he commenced inquiry and they at that stage never took up any, they didn't protest. They went with the inquiry.
But then
it's not that they didn't.
Only it's on 14/12/2017, this approval was granted.
Yes.
So at that stage, if suppose he had issued notice saying that apart from the 3 issues under 143.2, I am now going to make a complete scrutiny. So complete scrutiny means the earlier decision which he had taken not to examine the aspects goes, and he can, the entire return is open for fresh scrutiny. So that could not be done is what? Because 143.3 itself, it is said it is a very valuable. Of course, 147 is what do you say? It is a weapon in the hands of the department. But normally an assessee is entitled to an intimation. If he makes a proper return of income and you examine it under clauses A to D and you find nothing is there, you can give an intimation and be done with it. 143, one notice intimation will come. Matter is over. But once you say that no, there is an understatement of income or income, has escaped or there is excessive loss, etc., you invoke subsection 2. Thereafter, notice is given and inquiry commences. So that is why they say the sanctity of 143.3 in a scrutiny. They say unless you have fresh tangible material, even under the new amended 148A, still that concept remains because there should be a finality to a return. So therefore, the question of post facto approval or saying that the assessee did not object at that stage will not. That is why CBDT instruction is so clear.
That's why it's only for the inquiry stage, my lord. My lord will have to decide.
He had no jurisdiction. The approval granted by the commissioner was only with regard to the 3 issues. So he could not have set the clock back or said that
that was a limited scrutiny for the purpose of limited scrutiny. But later on, the approval was given for comprehensive.
After 14th of December, yes, that might have been a different.
But the assessment was that thereafter hearing was done.
Yeah, CAT appeals has gone into the and they are not on appeal against the disallowed portion.
No, they are.
Disallowed
portion. They have gone on the disallowed portion.
That they have not come here.
No, we have not.
No, they have not.
This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated February 23, 2023 passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA numbers 2611/KOL/2019 and ITA number 148/KOL/2020 relating to the assessment year 2015-16. The revenue has raised the following substantial questions of law.
Yeah, I take my lord's leave.
Yes. Page number 8, question A, question B. Question D, C not required. Sir. That's all. We have heard so and so. The short question involved in this appeal is whether the assessing officer who had initially issued notice under section 143 within bracket 2 of the Act for a limited scrutiny of the return filed with the assessee on 3 aspects could have expanded the scope prior to obtaining approval for a complete scrutiny by the appropriate authority. It is an admitted fact that on 26/7/2016, an order for limited scrutiny came to be passed. Subsequently, the assessing officer expanded the scope on 20th of February 2017 and commenced certain inquiries. The order granting approval for complete scrutiny was passed only on 19/12/2017.
14/12, madam.
14/12/2017. That is much after the inquiry was commenced by the assessing officer on 22/2017. The correctness of the same was tested by the assessee by filing an appeal before the Commission of Income Tax Appeals. Appeals within bracket CITA. The CITA, though noted the said issue, did not render a specific finding, but went into the merits of the matter and granted relief to the assessee to the extent indicated in the said order. The assessee as well as the revenue carried the matter on appeal to the tribunal. The tribunal examined the jurisdictional issue alone and noted that the assessing officer had issued notice under section 143 within bracket 2 dated 28/7/2016 for a limited scrutiny covering 4 issues, namely interest expenses, income from real estate business, sales turnover mismatch, and other expenses claimed in the profit and loss account. Subsequently, by notice dated 20/22/2017, issued under section 142 within bracket 1 of the Act, the assessing officer called for information on secured and unsecured loan deposits. And this was admittedly prior to the limited scrutiny being converted into complete scrutiny by order dated 14/12/2017. The tribunal, while holding that such action of the assessing officer was impermissible, referred to the circular issued by the CBDT in instruction number 5/2016, dated 14/7/2016. In the said circular/instruction, it was clarified by the CBDT that in cases under limited scrutiny, the scrutiny assessment proceedings would initially be confined only to issues under limited scrutiny, and questionnaires, inquiry, investigation, etc., would be restricted to such issues. Further, it has been stipulated that only upon conversion of case to complete scrutiny, after following the procedure as outlined in the CBDT instruction, the assessing officer may examine the additional issues besides the issues involved in the limited scrutiny. Full stop. The learned tribunal found that the procedure adopted by the assessing officer was in complete derogation to the instruction issued by the CBDT. The tribunal also took note of a decision of the coordinate bench of the Delhi tribunal in the case of Dev Milk Foods. Where is the citation? Dev Milk Foods.
Yes, my lord, the citation is at page 69.
Dev Milk Foods Private Limited was
ITA number so and so, my lord.
additional CIT
Yes.
ITA number 6767/DEL/2019 dated 12/6/2020 for the assessment year 2015-16. In the said decision, the learned tribunal had taken note of CBTT instruction number 5 of 2016 and held that the procedure adopted by the assessing officer was unsustainable. The tribunal in the case on hand, after taking note of the decision in Dev Milk, Dev Milk Foods Private Limited, held that that CBTT has clarified that in limited scrutiny, the scrutiny assessment proceedings would initially be confined only to the issues and questionnaire, inquiry and investigation, etc., would be restricted to such issue in the limited scrutiny. Thus, the tribunal dismissed the appeal filed by the assessee. Mr. Kundalia Leonard, Senior Standing Counsel for the appellant, placed reliance on the decision of the Honorable Supreme Court in Venkata Swamappa versus Special Deputy Commissioner Revenue, 1997, 9 SEC 128. They said the decision arose out of a case under the provisions of the Land Acquisition Act, 1894. The question was whether publication of notification under section 4 within bracket 1 of the said act in the local newspaper earlier to the actual publication in the Gazette was an illegality or mere irregularity. After taking note of the object behind the procedure regarding publication of notification as mentioned in section 4 within bracket 1 of the Land Acquisition Act, the Honorable Supreme Court held that it is only a mere irregularity and does not vitiate the validity of the notification published in the Government Gazette. In our view, the said decision can be of no assistance to the case of the revenue, more particularly having regard to the language or having regard to the scheme of section 1 of assessment as provided for under section 143 of the Income Tax Act 1961. Reliance was also placed on the decision of the Honorable Supreme Court in Commission of Wealth Tax, Meerut versus Shravan Kumar Swaroop and Sons, 1994, 6 SEC 623. In the said case, the question was whether Rule 1 capital B of the Wealth Tax Rules 1957 is a provision which affects and alters the substantive rights or is mere procedural. While considering the said issue, the Honorable Supreme Court noted the distinction between statutes affecting rights and those affecting mere procedure. In the instant case, the revenue cannot rely upon the said decision as the scheme of assessment as provided under section 143 of the Act is a complete code by itself. And the circumstances under which the power under subsection 2 of section 143 could be invoked has been clearly spelled out. And a reading of subsection 3 of section 143, it is evidently clear that on the date specified in the notice issued under subsection 2 of section 143 or as soon afterwards as may be, after hearing such evidence as the assessee may produce and such other evidence as the assessing officer may require on specified points, and after taking into account all relevant material which he has gathered, the assessing officer shall, by an order in writing, make an assessment of the total income or loss of the assessee and determine the sum payable by him or refund of any amount due to him on the basis of such assessment. Therefore, the question of part of the provision being procedural is an incorrect interpretation of the scheme provided under section 143 of the Act. Further, as noted above, the CITA has examined the merits of the matter and after taking note of the facts, granted relief to the assessee or to the extent indicated therein. Thus, for the above reasons, we find that the revenue is not made out any case for interference of the order passed by the learned tribunal. Accordingly, the appeal fails and is dismissed. The substantial questions of law are answered against the revenue.
Grateful, Lordship.
Yes, sir.
Item number 3.
But I'm appearing in this matter, but I'm led by Ms. Smita Dasdev in this matter. Here in this case, but the tribunal has deleted the addition made under section 68 of the Income Tax Act. But acts. But Lordship will kindly see here, my lord, the questions are at page 6, my lord, paragraph number 2, my lord.
Page 6 is
page 6, yes, yeah. Now, my lord, SSC has shown certain amount, my lord. Assessing officer found an aggregate sum of rupees 5.61 crore have been shown as sundry creditors in the balance sheet of the SSC for the relevant assessment year. The assessing officer issued notices under section 133(6) of the Income Tax Act to the respective sundry creditors, my lord, regarding the genuineness identity of the creditors, my lord. Some of the notice remained unserved, my lord. One of the cases, my lord, that Santosh Investment Private Limited, my lord, he appeared and he said, my lord, he had no transaction with the SSC. So, my lord, but he said he has no, my lord, even when opportunity of hearing was also given to them, my lord, to explain that how the transaction was entered into between the Santosh Investment and SSC, my lord, he failed to explain those, my lord. Now, if your lordship will kindly see straight away, my lord, the tribunal's order, my lord. My lord, tribunal's order, if your lordship will kindly see, my lord, my lord, it starts at, my lord, page number 68. Now, my lord, the brief facts has been stated in page number 69, my lord, paragraph number 4. Brief facts of the SSC's private limited company engaged in the business of trading. Nil income in the return was filed. My lord, thereafter, my lord, for the assessment year 14-15, based on the
completely factual.
There are, yes, my lord, lordship will kindly see, my lord. But my lord, only one thing, my lord, that my lord, he was asked to produce, my lord, genuineness, creditworthiness of particular transaction, but he failed. But that's why, my lord, 60 notice, my lord, the 68% of initiate, my lord. The tribunal has, my lord, to my humble submission, my lord, without going into the details of the fact, my lord, he has deleted the addition. My lord, subject to correction. My lord, he has gone, but
CIT appeals has also gone into.
Yes, yes.
Even in your grounds, ground number 3, Santosh Investments, that is ground number B.
But Santosh Investment, my lord, he was asked to produce, my lord, the details of, he said he had no transaction with the SSC. But if your lordship will kindly see the operative part, my lord, lordship will find, my lord, that tribunal's order, but we have found, my lord, paragraph number, my lord, 9. We have found that I will contention peruse the record placed by for us the sole grimace of the revenue is the CIT appeal has erred in deleting the additions made by the assessing officer for the unexplained.
No, you come to paragraph page 72.
Page 72, my lord.
Third line, genuineness of the purchases of the equity shares held has not been disputed by the revenue authorities. Only dispute to the buyers of the equity shares have not been able to prove the source of payment. Assessee before the lower authority before us filed various details of the alleged loan creditors to prove identity, creditworthiness, as well as genuine. Relevant part of the index of the paper book contains the details also. See all the details, etc., etc.
Details are given.
Further, page 75. Notice information called for by learned assessing officer 133(6) were duly served upon all creditors, and even in the remand proceeding, most of the loan creditors have confirmed the transaction. Only in some cases, creditworthiness was doubted based on small amount of bank balance. Assessee has filed the following details. Further, we notice nowhere in the course of assessment any dispute has been raised regarding transaction relating to purchase of equity shares made by the assessee during the preceding year. Neither the sale transaction was disputed. Only the consideration received against such held as investment in the current year has been disputed by the AO. Since all details necessary to prove the identity creditworthiness also has been discharged, primary owners cast upon it, and therefore correctness remains rebutted by the layer there. We fail to find any invalidity in the finding, further supported by the so and so win my. What more do you want, Smita?
No, yes, my lord. First of all, your lordship has taken up the question of law. Now there we have indicated one loan creditor's name, that is Santosh Investment Private Limited, because we are more harping on that particular company, the loan creditor. Now your lordship kindly takes up the CIT's order starts from 19, but there is a remand report which has been reproduced in the CIT's order itself. If your lordship, page 28 is the remand report. Now, if your lordship kindly takes up the names of all the creditors, your lordship, and then your lordship kindly comes to page 33.
Santosh Investment.
Yes, my lord.
No reply.
17, yes. That the identity, genuineness, and the creditworthiness of the said transaction could not be justified. Now, out of those 11 parties, now this particular, they were served, but they have not, it is returned back. It is there in the assessment order itself. Now that could not be justified. Now the tribunal's order, it's simply on the basis, it's a general finding of the, has not indicated anything with regard to the Santosh investment, my lord.
Page 73.
Yes, my lord.
This is a paper book, extract of the paper book.
Yes, that has been given it.
Index, it says.
Yes, that the bill for sales of investment.
Bill for sale, acknowledgement, source of fund, bank statement. So this was filed as a paper book at page 72.
Yes, my
The
lord.
tribunal says. Have you got a copy of that?
Yes, yes. Tribunal. No, you don't, because it's all annexed here, your lordship, but that is there. But in the order itself.
Maybe true when the assessing officer issued notice.
Yes.
He did not respond. But what they say is.
Because we are also, we were taking care of that remand report also, because the remand report, on the basis of that, we have proceeded, your lordship. So then again, the order which was taken care of the tribunal is in respect of those issues which were also taken before the assessing officer, your lordship. That could not be proved. And then there is a one statement of the Santosh, he's denying that he doesn't know, this company doesn't know this appellant, to your lordship. That is Gemini. If your lordship kindly comes to page 15.
To be very candid, my lord, we have the paper book. Like to produce that. My lord, for Santosh, I find that the bill of sale of investment, that is there. But my lord, the amount is 20 lakhs. If the appeal is limited to Santosh, then it is below monetary effect appeal. If it is all limited to Santosh, then this appeal does not stand. For other creditors, everything was shown. And that's a part of the record itself.
If your lordship kindly comes to page 14.
20 lakhs.
They have given a written submission where he stated that we have not given any loan to Gemini, and we do not know any such company.
Let us see the finding of the CIT appeals.
Yes,
on
my
this
lord.
Santosh.
Page 25, my lord, is the decision of the CITA.
No, operative portion. Text Maharaja, Kokila, Hexagon, Switchgear, Tooth, Nidhi, Sreet, Sudarshan, Bifildar, Blackberry Goods,
CIT last, CIT last, Last 10 minutes. It's a one. No, 68 এর আগে 67.
67 also. No, CIT.
My lord is taking
No, CIT appeal.
66, page 66. The decision starts from that page, but the
No,
fine
up to that, it is extract of.
extracted from another judgment here. There's a Justice Indira Banerjee's judgment, which they have relied upon. And that is the entire extract from that.
That
Page
is that,
66, my lord.
Nishan Indo-Commerce.
Yes, my lord. Page 66, your lordship kindly comes.
That's the only finding.
That's the only finding. The entire order that has been covered with the remand
what
report
is
and the
Vasudha,
Yes.
it's a very easy way of writing judgment orders. You
CIT
extract,
appeals order, your lordship is appealed.
extract 40 pages,
Yes.
matter be over.
This is the boon and bane of information technology. My lord. What more can I submit?
See, from which page the commissioner's orders starts?
Let me find it out.
commissioner order starts from page 19 and
19.
page 19. But the
Then-
finding is actually it starts from that particular 44, but here, if your lordship kindly comes to page 66. 4.7. That mark positioning.
So first he extracts the assessing order.
Yes, then he gives the remand report. In between that remand report and the assessment order, there is this decision starts, page 25.
But page 25.
Yes.
But page 25, he gives this finding. During the case of course of appellate, assessee filed a paper book containing 414 pages. During the year under sold to 18 parties. Due to some dispute, share transfer could not be completed. Therefore, money received from 18 parties shown as credit. Assessee furnished the complete details of the transaction and furnished the following: 1, 2, 3 identity, etc.
Yes, then
As the documents were not before the AO, the whole compilation was forwarded to the AO. Report was called for from the AO.
the remand report which was called for from.
But already, assuming Santosh alone, he has not examined. Huh?
Madam Santosh Agarwal, madam, no response was received from Santosh Agarwal. Santosh, that company. Your lordship will find that.
133.6 notice was issued, but
Yes,
they have
yes,
not
there was
done
no
that.
response. Your lordship will find that in the.
The assessment order also, your lordship, and even in the CIT's order, even in the tribunal's order.
Santosh, your lordship will find.
Page 33, your lordship, that is the remand report which has been
But
annexed to
but in
the.
the remand report, he says the creditworthiness has not been established. So at least one exercise they should have done.
But madam, these are the shares which were held by, this is not assessee shares. These are the shares held by the assessee shown in its books of accounts. But during this financial year, my lord, the arrangement was entered into by and between the assessee and these 9 or 10 or 11 or 12 parties that they will buy certain shares from the assessee which were held by the assessee. These, my lord, for which these parties made advances. And my lord, those everything has been recorded. And you know the tribunal's order records everything. Except for, my lord, as suggested by Mrs. Dasde, that Santosh, there was no response under.
No, tribunal also
Yes.
doesn't consider. See, first of all, CIT appeals has not considered the effect of the remand report. Remand report clearly says that fellow had a bank balance of only 32,000 rupees. How he could have purchased shares worth several lakhs?
At the opening balance.
No, maybe.
But at the opening balance.
Once the AO, I mean CIT appeals invites a remand report and the AO in no uncertain terms, he says all the, purchases, creditworthiness is not been established. So therefore CIT appeals has to go assessee by assessee or purchaser by purchaser.
Right. And what has been done, my lord, before the tribunal, we had submitted these paper books. In these paper books, apart from Santosh, with respect to each another SSC.
But tribunal referred only to the index. That's.
But
You see?
that is there. That is there. It's a
Probably oral submissions might have been made 1 hour, 2 hours, etc.
we
But
have
the relevant part of the index of the paper book is reproduced below.
but it is there.
No, we will send it back to the Commissioner Appeals.
Commissioner Appeals.
He held in your favor. Let him write a proper order. Instead,
May I just make this submission before Lordship? If your Lordship kindly takes the grounds taken out in the memorandum of appeal, it is only limited to Santosh.
No,
it is all about Santosh now.
Now, ground number
the submissions
A,
which have been advanced on behalf of the
ground number A,
yes,
delete additions made in the absence of any cogent and reliable evidence establishing identity and credit worth. A will encompass everything.
But my lord, it is the ground, Santosh ground, which has practically driven the department to prefer this appeal.
Probably the officer, he could place his hands only on.
My lord, the only issue which troubled, my lord, two issues, my lord. May I respectfully submit to your Lordship? But so far as the creditworthiness of these parties are concerned, my lord, all the materials were produced before the tribunal. My lord, it is there on record. The tribunal takes note of the paper book. My lord, only with respect to Santosh, my lord, only the bill of the sale of investment was produced before the learned tribunal. My lord, if your Lordship kindly takes the remand report, in each and every case, they say about the opening balance. They do not say about the accounts maintained by the respective assessees. They do not say anything about the respective.
No, let us say just the agency.
Yes, ma'am.
They say the company shown an income as nil and claimed current loss at 790. Company had no business during the financial year 13-14.
Current loss, my lord. Current loss. May not be that loss relevant to that financial year.
No. We will send it. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the act is directed against the order dated 15th March 2023 passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket tribunal ITA number 14/K/2021 for the assessment year 2014-15. The revenue has raised the following substantial question of law for consideration. Only question A, sir, page 6. We have heard some. The assessing officer by order dated 20th December 2016 completed the assessment under section 143 within bracket 3 for the assessment year under consideration within bracket AY 2014-15. The assessing officer, after issuing show cause notice to the assessee, came to the conclusion, no, disallowed substantial amount as unexplained loan creditors of the assessee. The assessee filed appeal before the Commission of Income Tax Appeals within bracket appeals -4 numerical 4 Kolkata within bracket CIT. Before the appellate authority, the assessee appears to have filed a paper book containing certain details. Therefore, the CIT appeals called for a remand report, and accordingly, the assessing officer submitted a remand report on 17/9/2019. On a perusal of the said report, it is seen that in respect of each one of the transaction with the 18 companies, the assessing officer came to the conclusion that their creditworthiness has not been established, and their identity also in certain cases has not been established. Thus, what was required by this CITA to examine was the correctness of the information furnished by the assessee with reference to the remand report which has been called for. Though at the first blush, the order passed by the CITA appears to be an elaborate order, on a closer scrutiny, we find the same to be otherwise. This is so because the CITA has extracted the entire judgment of this court in ITA number 52 of 2001 in the case of Commission of Income Tax, Central 1, Calcutta, versus Nishan Indo Commerce Limited. And after extracting the entire decision, the finding rendered by the CITA is only in the last paragraph, stating that the assessee has discharged its onus by providing sufficient documentary evidence to the assessing officer. We find there is absolutely no discussion on the documents which are placed by the assessee as well as the opinion rendered by the assessing officer in his remand report. When the matter was carried by the revenue to the tribunal also appears to have committed the same mistake, or rather being swayed by the volume of documents placed before it in the form of a paper book. The tribunal would state that the tribunal has extracted the index portion of the paper book and has come to the conclusion that the CITA was justified in setting aside the disallowance. Unfortunately, the CITA did not examine the merits of the matter, and all that it did was to extract a decision of this court in the case of Nishan Indo Commerce Limited, and in the last paragraph made a cryptic finding that the assessee has discharged his onus by providing sufficient documentary evidence to the assessing officer. Thus, in the absence of examination of facts, either by the CITA or by the tribunal, we need to brand both the orders, that is, the order passed by the CITA as well as the learned tribunal as being perverse and thereby required to be set aside. Accordingly, the appeal is allowed. The order passed by the learned tribunal and the order passed by the CITA appeals, CITA dated 21/9/2020 are set aside, and the matter is remanded to the CITA for fresh consideration. The CITA shall afford an opportunity to the assessee as well as the department examine the documents which have been filed by the assessee, and also take note of the findings recorded by the assessing officer in his remand report dated 17/9/2018, and thereafter pass a speaking order on merits and in accordance with law. Consequently, the substantial question of law is left open. Thank you. Next. Allowed.
May I make one humble prayer? Would your lordship make it clear the lordship has not gone into the merits of the claim?
Obviously. Because otherwise our order is also perverse. Make it clear that the merits of the matter has not been gone into.
Grateful.
And it is for the CIT appeals to examine the same thoroughly.
So grateful to you.
Great. Next.
Item number 4.
But I'm a paid for the may I file service. But in this case, SSC is in the business of medicine, my lord, wholesale. But what has actually happened, my lord, SSC has paid more than 1 crore rupees in cash to in violation of 40A3, my lord. And also, my lord, there's a transaction with another company who has denied the transaction. Actually, no transaction took place of more than 3 crores. That was an admitted fact, my lord. My lord, the lordship will kindly see. May I just indicate one thing, my lord? The SSC, my lord, he has paid rupees 1 crore 22 lakhs such cash to one of Mr. KD Enterprises, which is more than the prescribed limit. Let's say 40A3. The SSC was requested to furnish the explanation of this matter, which was supporting evidence, but no explanation was given in spite of the issuing several letters. My lord, during the course of assessment proceedings, it was also found that the purchase of rupees 3 crore 59 lakhs was claimed to be made from Aditya Medicals, but no response to the notice under section 133(6). The Aditya Medicals Limited confirmed that total sales made to the SSC was to the tune of rupees 3 crore 81 lakhs 84,594. The SSC was requested to furnish the explanations and reconciliation of the difference amount of rupees 22 lakhs 21,577. But in spite of assuming several notices, he could not reconcile those things. But if your lordship will kindly see, before coming into the tribunal's order, lordship will kindly come to CIT's order. CIT's observation is critically, is in detail observation was made by the CIT. CIT's order starts at page number 25. Page number 26, brief facts were given. What is the brief facts? Thereafter, page number 26, 2.1.2 from the respective bank statement appears that the huge cash amounts were deposited in the bank account of the SSE during the demonetization period. In view of the above, the SSE was requested to furnish the details of the business and the modus operandi of the business, as well as
No.
furnish.
Absolutely perverse.
My lord.
We are telling Himanshu.
Yes.
Absolutely perverse.
Yes.
My lord.
The fellow depositing 1 crore, 2 crore cash.
Yes.
Maybe he is having a 32 crore turnover. Small time fellow agriculture.
Only, my lord,
buyer,
what he
he
has
is giving more than 20,000. He can't because of the nature of business activity he is paying.
May I submit, my lord?
No, you submit later after 1 year.
My lord.
We'll admit that.
Yes.
This is all absolute. This is clear way to get over demonetization.
My lord, demonetization only 21,000, my lord. Money deposited.
No, money, maybe 20,000 is the limit.
No, my lord,
You
I'm
directly deposited the bank
my lord,
account.
this is the medicine
more than
business,
1
my
crore.
lord.
It is maybe what medicine?
My lord,
This is all
wholesale
hawala. No medicine business.
medicine business, my lord.
Medicine business, and he is an individual.
Individual, my lord.
32 crore turnover.
And directly deposited, they
We
collected
have
from.
heard so and so appeal is admitted on the following substance A, B, and C. Page number 7. Usual order. Let it be there. Clear case of
Item number 5.
should have been booked under money laundering.
No, my lord,
Crucial period. And do you mean to say that he paid the stockist 32 crore turnover, everything in cash?
No, cash deposited directly in their accounts.
Maybe
Some
that
part.
is wrong.
And my lord.
How can you do that?
Yes, my lord. And my lord, medicine in this medicine trade practice, my lord, they agents,
What
sales
sort of
agents,
medicine?
wholesale medicine, my lord.
Hope it is nothing NDPS.
No. That's not the issue, my lord. So appeal admitted, my lord.
Appeal admitted. Next.
Item number
But
5.
I'm appearing for the appointment. I have served, my lord. They have assessed has received, my lord. The lordship will kindly take it up next day.
I'm good.
No, lordship will kindly make it next day. Again, my lord will serve because they have received, my lord. So the questions are at, my lord, lordship will kindly see the questions, my lord. But in this case, my lord, the SSE, the questions are at, my lord, page number 7, 4, paragraph number 7, my lord. My lord, the justified in deleting the disallowance rupees 2 crore 54 lakhs made by the assessing officer under section, my lord,
penny stock, is it?
68 of the Income Tax Act, my lord. Yes, my lord, it's not penny stock, not disallowance under section 68, my lord. Mainly 68, my lord. The lordship will kindly take it up next day, my lord. Wednesday. Again, we'll serve, my lord. Because here, my lord, mainly disallowance under section 68, my lord.
All right. List next week. Awaiting service of notice on the response.
But service has been filed, my lord. They have received that, my lord. They have SSE delivered.
Okay.
It has been delivered. Well, again, we'll intimate.
That Miraj D Shah.
Miraj D. Yes, I'll inquire from
Pratush
sometime. Yes, I'll inquire.
You will or you will appear. You inform. What is it? Notice has been served on the respondent. Affidavit of service has been filed. List the matter next week. Next.
Item number 6.
Well, I have put the appeal in my lap.
Led by Mr. Kundalia. Kindly pass it over, my lord.
For next week, my lord, I have some difficulty. Grateful.
I think.
Item number 7.
Wait, please, Your Lordship.
I am for the
This matter, I am led by Mr. Abhitosh Majumdar.
Pardon?
I am led by Mr. Majumdar in this matter.
This is, my lord, an intra-court appeal, my lord, being preferred by the petitioner, if your lordship. The order assailed, my lord, the order.
My lord, the 148 AB notice is at page 59. My lord, will find at page 60. They refer to the inside portal
And on the basis of the information derived, my lord, Mr. Singh is here.
Madam, please kindly give me a minute. Your lordship kindly takes the first 148AB notice. This is at page 59.
Yes.
Lordship kindly takes a search. This is from the fourth paragraph I'm reading. Page 60. This is the annexure to 148AB notice. A search and survey action under section 132 of the Act was conducted at various spots of finance brokers Savaria and Kasera on 30/11/2018, and the assessee Sri Shyam Sundar Dhanuka was a beneficiary of the finance broker, has received cash loan of rupees so and so from Uma Shankar Kasera Pan so and so during financial year so and so relevant to assessment year 2016-2017. If lordship kindly turns over and take the Insight portal, your lordship will find the remarks column. The remarks column says that he is a beneficiary of finance broker, not cash loans and etc. It says, my lord, if your lordship kindly takes the reasons contained in the annexure, it says about a receipt of cash loan of so and so, and this is now beneficiary. So this is the information which triggered these proceedings. Now, my lord, kindly take the statement of this Uma Shankar Kasera, which was also forwarded to us along with this 148AB notice, which starts at page 68. I did not trouble your lordship with the entirety of the notice. I do not find, subject to correction, any mention of Shyam Sundar, this Dalmia.
No, that's the reply also.
That's the reply also.
Page 82, it says.
Yes, it says.
On
Clearly,
perusal of
clearly.
statement, it is noted that no mention of the assessee's name.
Yes,
in
82
this
bottom,
incident.
82 bottom. Kindly take page 83 for once. What we do, we know that they are launching a fishing and roving expedition. So kindly take the fourth paragraph at page 83. You are requested by law to provide the assessee with any evidence in your possession on the basis of which you have alleged that the assessee had received or lent cash loans of 40.70 crores, without which the said allegation is not sustainable in law, and it does not provide the assessee a fair opportunity to rebut the same, leading to failure of principles of natural justice. Your good self has not provided any material against the assessee which even remotely shows that the assessee has had any such alleged cash transaction or sale of property transactions. This is my categorical assertion that the material on the basis of which these proceedings have been initiated were not supplied to me. Well, now I take your lordship directly to the order. It starts at page 85, dated April 7, 2023. Kindly take the first 3.1. This is important. Page 87. Last sentence, my lord, at page 87. My lords have got that? Hence, no inquiry is required as the information available itself. Prima facie opinion of escapement of income. This is the first session. Then they refer to the show cause notice, the reply. But interestingly, in the reply which the petitioner submitted, though the petitioner sought for material and clearly indicated that in the absence of material, the assessing officer cannot proceed, that issue has not been dealt with. Then, my lord, comes the conclusion. My lord, this conclusion is very interesting. Your lordship will find similar conclusions in all these kind of cases because this is the usual template now. Another boon or bane of information technology. Your lordship will find Merriam-Webster being referred to, sometimes Macmillan Dictionary being referred to. Now, my lord, kindly come to page 90. My lord, I tell your lordship, from page 89 bottom to the last, but the third last paragraph, it is usually the same template which is being employed in all these cases. My lord, kindly take your lordship to page 90. In the given case, there is sufficient evidence as stated in the following paragraphs, which suggests that income has escaped assessment. In the investigation report received from the Office of DGIT investigation, there are some remarks about potential borrower lender. However, on verification of documents, it is seen they are credible. He says that no inquiry is necessary. Then he says there has been a verification. Well, the verification can be done only at the stage of clause A of section 148 capital A. Then only a notice under section 148A will be issued, and I will submit a reply under 148AC, and then an order upon consideration of my reply and the information will be passed under 148AD. Then Miller, kindly take Miller the next page.
But there are some documents, sir. If you see,
yes,
it was probably first 5 paragraphs may be a template.
Right.
In page 91.
Yes.
It says these documents, white so and so.
These documents were not provided at the stage of 148AB. Well, I could have confronted these materials had these materials been provided to me. Kindly take, my lord, this is very important. They say that I am a beneficiary of a financial broker, namely Umashankar Kasera. I am not aware who is Umashankar Kasera, but now they say, kindly take the last paragraph. After dealing with this 69C, 269SS and 269T, on examination of seized documents, YD ID mark USK 6 found and seized from the residential premises of finance broker Praveen Kasera. So, now we find 2 actors. One Umashankar Kasera, another is Praveen Kumar Kasera. We are not provided any material now from 92 onwards. To my lord, this kindly take, my lord, the page. This is 93, right? Kindly take page 93 for your lordship's kind consideration. Your lordship will find that these are the materials which were seized from the residential premises of Praveen Kumar Kasera. From 93, this goes on. This square, triangle, circle, I don't know what are the implications of these.
Now,
geometrical figures.
One clarification.
Right.
Page 64.
I'm coming back to page 64.
This was appended to the notice.
Which was, my lord?
Page 64.
Yes. Yes, this is the modus operandi.
Yes. This is now USK 6. USK 6 relates to the assessee. In this annexure,
the USK 6 does not relate to assessee. USK 6 is, according to them, is a document recovered from the office of Praveen Kumar Kasera, but relatable to USK. My lord, if I take the acronym, it would be Umashankar Kasera. It is not the petitioner before your lordship. Even if I take the acronym, if I take the initials, my lord, the initials have a big role to play in these kind of proceedings. But one may have initial, in this court, there may be 5 persons having the initial of AM. But I am the mischievous one. What will happen to the other 5 AM? Will they also be implicated? That is the question I put to myself.
But the reply given by the assessee was also a template.
No, my lord, that's not a template, my lord.
That's also a template, obviously.
Kindly take, my lord, the reply
Along
for
with
one.
your notice, you have enclosed a letter of the DDIT dated so and so, wherein modus operandi unaccounted cash loan transfer discussed. However, is not understood as to how this letter leads to the inference that the assessee has given cash loans.
Yes.
So that to that extent, he has said.
Yes.
But
what more can he say at that stage? Well, I had those materials which start from page 92, right?
Assessee had knowledge.
Well, from 93 to 104 If those materials had been provided, then the assessee would have been in a position to confront those materials. This is the question I put to myself with all humility. Then my reply would have been a detailed reply.
So this was not furnished to you at the first.
No, my lord, it is admittedly not furnished. No, admittedly not furnished. Kindly take, my lord, kindly, I take your lordship a little.
You could have sought for some examination. It is not as if the assessee doesn't know this person. He can't feign ignorance. He obviously, on
at
record,
this-
he doesn't know.
My lord, at this stage, my lord, the assessee, my lord, having regard to the position of law as it stands now, assessee cannot be made to implicate himself.
That's he can't be.
He
compelled to-
cannot incriminate. Self-incrimination would go against the rule of law.
No, he can't be compelled to give evidence against
Himself. At this stage, my lord, at this stage. Now, my lord, kindly proceeding a little further, after this table ends at page 104, your lordship will find from page 105 to page 107 quotation, correct? Page 107. When they refer to some the settlement commission order. They should have provided me with the copy of the settlement commission order, which forms the basis of the 148 AD order. So, my lord, the cardinal principles, my lord, procedural infirmity or irregularity, illegality or irrationality. The three are, my lord, well said, well etched in this order. And then, my lord, the borrower. Well, if I am the borrower, your lordship has already expressed a prima facie view in one matter, subject to correction. Kindly take, my lord, this order. Actor Tilok keu dite hobe. Mr. Mitra is aware of this order.
No, eventually I was aware, but that's on a different, but the facts are different.
Yes, yes.
Facts are different.
In this, we are granted
This
an
is
interim order.
this is the ED.
No, we granted an interim order.
Your
here.
lordship
Yes,
granted
that's
an
on a
interim order,
different
and lordship
score,
has, your lordship was of the view that the learned senior counsel, your lordship at this end, has also made observation. Substantial challenge to the, may I just read out this order?
No, there the learned single judge referred the matter to the enforcement.
Yes, that was on a different score, my lord. Your lordship had indicated that why it was.
Well, I was at the
stand for it.
receiving end on that day. I was at the receiving end. But, my lord, whatever, these are questions of law. And, my lord, opportunity
But
has
you
to be
see,
given.
They should have furnished all materials.
All materials.
To link the.
Well, there has to be a live link has to be established.
But this is pure circular transaction.
Well, I tell your lordship, I tell your lordship, an arc is missing in the circle.
That may be one reason for which, my lord, my learned senior friend could have come up before lordship and say these things, because this is such type of scam, my lord, wherein, my lord, everything cannot be, my lord, put in a box. Now, my lord, this 148 AB, 148 80, these proceedings, my lord, my lord, the scope by which, my lord, read court would interfere. My lord, there are these rules are, my lord, so well settled now, because the point which my learned senior friend is harping is more of a merit of the matter. Now, my lord, 148 AD order is not like, my lord, a criminal judgment, wherein, my lord, the assessee will be put into the box and there will be conclusiveness of the evidences that is, my lord, proposed to brought for it has to be examined. Because still there is an assessment procedure, my lord, my learned friend can participate there, and, my lord, all these issues can be raised there in, my lord. Otherwise, my lord, the entire exercise will be a futile in that case.
You heard Mr. Mazmundar, Tilak Mitro, Amit Sharma. Judgment reserved. So we'll stop with this. One meeting is there. No chance.
The next matter, which is of the same assessee.
Same
If
matter.
your lordship sees the facts.
Identical.
No, it is more astonishing and amazing. 3 148 AB notices issued. 2 on the same ground.
3 148 AB.
3 148 AB for the same financial year, for the same assessment year. Would your lordship take it up, my lord, lordship?
No, we'll take it up Let it remain in the list.
The only
uh,
difficulty, my lord, on Wednesday, my lord, if from Wednesday, my lord, I am little bit uncertain. If I am held up, my lord, Mr. Bagaria will.
We can always.
Grateful, my lord.
Grateful, my lord.
What to do, sir? You could have had the other engagement today. Anyway, that one is still option. So let it remain in the list like this.
Hello, only one thing I will trouble your lordship in respect to item number 9. But on Wednesday, there is some personal difficulty. If your lordship kindly keeps this matter on any other day apart from Wednesday, we are for the responding. Mr. Odijit Chakraborty is appealing for the appellant. I shall inform him. I'm grateful to you.
Grateful.